You're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, sir.
On March 28th, 2025, an officer was in the process of serving a capital murder warrant on a suspect in Harris County, Texas. While conducting a felony stop, the defendant, who was identified by his Texas ID card, pulled up on the officer's perimeter, got out of their motor vehicle, and began walking to the residence where the murder suspect was. The officer's supervisor ordered the defendant to stop and stay right there. The defendant refused and continued to ignore officers while walking towards the residence. The officer's supervisor ordered the defendant to step back multiple times and then grabbed the defendant and took him to the ground.
Him?
Yes, Your Honor.
Was he the capital murder suspect?
No, Your Honor.
I live there.
Stop.
Oh, sorry.
I believe that they were in the process of serving a warrant on someone else at the residence, and that's when they came in contact with the defendant. Ordered him to stop. He refused to stop going towards the residence. Your Honor.
Did it serve the warrant? What ended up happening?
Looks like after refusing commands, there was a brief struggle where he was detained.
Was the murder suspect there?
I'm not sure, Your Honor. It does not say. I have no further facts that show if the warrant was service was complete on the warrant or not, Your Honor, or completed at the time. I just believe they were in the process and believed him to be at the residence, and that's when this incident occurred.
Read it again, if you don't mind.
Yes, Your Honor. On March 28, 2025, the law enforcement officer and Squad 5 of the Houston Police Department's Gang Division served a capital murder warrant for a suspect observed inside a truck at a nearby residence. While conducting a felony stop, the defendant, who is identified by his Texas ID card, pulled up on the perimeter, got out of the vehicle, walked to the sidewalk, and began walking to the residence where the murder suspect was. The supervisor then ordered the defendant to stop and to stay right there. The defendant refused and continued ignoring officers and walking towards the residence. The supervisor ordered him to step back multiple times, but the defendant was once again ignored the officers. The law enforcement officer grabbed the defendant and made him bounce and took him to the ground.
Okay, so now, but when you first started, you said they were going to a capital murder suspect in a car.
Yes, Your Honor. That's what. So I was originally reading the summary, and I'm going straight from the gems now, Your Honor. It looks like the suspect was observed inside a truck at a nearby residence.
So the suspect is not even in the residence. No.
Then they later state that there was that the suspect, that the defendant here was walking towards the residence where the murder suspect was. I'm not sure, Your Honor. I'd have to put that.
If I know probable cause in your case, just be careful, man. When you get into a pissing match with
I understand.
who's going to win?
They are. I understand.
No?
Yes, sir.
All right. Hand,
All right. Did that?
please. It looks like you have a fugitive case. Oh, you picked up 3 cases. You picked up a fraudulent use of ID, less than 5 items. You picked up a theft case, and you have an out-of-state fugitive case.
One of them has been dismissed, Judge. The fraudulent use of items has
Saw
been
that.
dismissed. So technically, he's only got the theft pending and the fugitive case pending.
Mr. Kim, enlighten us.
Your Honor, this defendant is wanted out of Broward County, Florida for felony theft. The state would be opposed to a bond. There are 47 cycles of criminal history in the past 5 years alone, and these are just convictions.
47 pages of criminal history in 5 years?
47 cycles, Your Honor. For pages, it is 46 pages of criminal history, including, well, the California one's old, so I'm not going to count that one, but just in the last 5 years alone, and these are just.
They were not 47 in the last 5 years.
The thing is, Mr. Jones, is I have a very limited amount of time to try to get to know you. Everyone that comes in front of me tells me it's gumdrops and rainbows and little bunnies jumping in the woods. But the way I really get to know you is the paper, because that tells me who you are, right? If you're a dangerous person, if you're a person that I'm going to let go and you're going to continue with the criminality, I have enough trouble sleeping as it is. I don't want more blood on my hands. I don't want something else that's going to keep me up at night. So that's why. Well, but this is how we get to know you. And he's telling me you got 46 pages of criminal history.
Your Honor, in the past 2 years, he's had 3 failure to appears of multiple cases. He's had 2 habitation trespass convictions, a DWI, prostitution, battery, criminal damage, failure to appear, possession of drugs, felony, obviously, resisting. But in the 21 some odd years, it's the 47 cycles of different offenses, and I just stopped scrolling after 2020.
How many failure to appears do we have?
3, Your Honor. And this one itself is a no-show, or according to the transmission.
Hey, John, could I say something?
Sure.
Okay, with the one you talking about with the failure to appear, I feel that was nonsense because of the simple fact that I flew from Fort Lauderdale up here after they said I had a warrant, and I went to court a couple days before that. And is that documented, sir? You can see that?
Judge, I will say this, he did explain that
How
to
old are you,
me.
Mr. Jones?
I'm 40 years old, sir.
You're 40.
Yes, sir.
How many cases has he picked up in total?
That he's been charged with. If you give me 10 minutes, I can count them, but it's not low. I mean, I can start from 2004.
So
if you want me to.
theoretically, for every year you've been born, you've had a case.
I have a
You're
question.
40 years old,
Okay,
and you
sir.
have around 46 pages of criminal history. So literally for every year you've been born, you've like picked up a case. And not only that, you've got multiple failures to
Sometimes you don't think the jurisdiction will fail me?
Huh?
You don't think the jurisdiction will fail me?
But the problem is, at some point, your actions become your own. You now have with us, you've picked up a theft case here in Harris County. You've got an open case in another jurisdiction. You've got pages upon pages. So at what point is it on you?
When you pay your debt to society, why do they keep using it against you? I pay my debt to society for
Because
those,
it continues.
hires, okay.
Continues to happen. At some
Okay.
point, DAs are like, jail just doesn't work anymore. So that's when we got to go to prison because this dude,
But prison don't help guys. That don't make them better. That makes them worse. Instead of tormenting them and sending them and feeding them to the wolves, y'all should sit down with that person to find out what's going on to help that person. Instead of prison not helping nobody, prison is not.
I can't tell you how many stories I have read of people who get degrees, college degrees, even become a lawyer while they're in prison. So if you want it to help, then it will. But you got to want it. If
Nobody
you,
one better than me, Your Honor.
if you
But
have-
you know what the sad thing about it is, in the state of Florida with me, and that's why I left. Something happened, and I have a conflict of interest against the police. So now they're jigging at me every chance that they get. But it's crazy. He's saying I have a warrant, and I flew from there after that warrant was pro se. Pro se that they said I have. I flew from Fort Lauderdale all the way to Houston, flew back down there, and flew back. And they said I have a warrant, and I flew and went to court for another charge down there.
I don't get it.
And I went inside
I
the
don't know.
court.
I don't know how that happened, but it's not supposed to.
So who's the system failing? If I have a warrant, you mean to tell me they're gonna let me in their courtroom, attend to my judge, see my judge, everything, and let me go, and let me get back on the plane to fly back here? Mind you, I flew from here and flew back down there. They let me do all of this with a warrant?
I can't explain that. I can't.
So that's the system failing somewhere, somehow. That's not me.
Let me talk to the judge real fast.
But Mr. Jones, if you have this woe is me attitude, it's never going to change. It's
Y'all not
never going to
helping.
change.
Y'all not helping. It's not helping. Y'all not helping society. Y'all always blaming me and this and that and the other. Prime example, he's saying, oh, he got prices from here. And he went to call the stuff off. That he said, well, only stopping from 2022, and he going past 2022. And I'm like, yo, but that's what the prosecutor do. He just doing his job.
Right. That's what he's doing.
Judge, if I may, a couple points. First, if he's finished up the cases that he has had in his history. He's had a history, okay, he's had a history. If he's paid his debt to society, like he says, if he's completed what he needs to do for those cases, that really shouldn't be relevant here. I would argue that in front of you, this is his first time being in front of you, right? And it looks bad that he has criminal history. Yes, I get that. But if we were to just focus on whether or not he knew about this case, he's telling me he got on a flight, came over here, and it's a great question. If that happened, he would have had a warrant pending and he would have been arrested.
When
So
was the warrant issued, do you know?
March 3rd, 2025, but because it's a domestic flight, and obviously I don't work for TSA, I don't work for Department of Homeland Securities.
Just got issued.
just March 3rd, 2025, Judge.
Your warrant was just issued in March of this year. So
And I flew,
30 days ago, it got issued.
and I flew March 10th back up here.
So Judge, if that's the case, it hasn't been like he's been missing his responsibilities with
And
this
I went to
case.
court, and
It's
you-
less than a month.
And you can
That
also
he's had
see
this
that I
warrant
went to
pending.
court. I went to court before March 3rd.
That's why it's a failure to appear, which is
How? I went to court. I went to court before then.
Judge, the warrant has
I was
been
in the
issued
courtroom.
we're at April 1st, less than a month. And so it's not like he's been running. If the warrant's just been issued on March 3rd, I would ask that we afford this man an opportunity to make this right. He hasn't messed up in your eyes. Yeah, he's messed up in the past, but as far as the fugitive case is concerned, I'm asking for an opportunity for him to go to the demanding jurisdiction. And then if he messes up, okay, well, I don't have much to say after that. But just throwing his history out there, it doesn't mean he doesn't deserve a chance.
I stand by the no bond. He has assaultive history as well, and it shows in the message that we received from Florida is that he has violent tendencies, obviously reflected by the assaultive history, along with and I don't have to go ad nauseum, but the significant criminal history that he has.
When were the FTAs? How long ago?
The most recent failure to appears, one moment, Judge. There's one from May 4th, 2023. There's one from December 7th, 2023. There's one from,
But it's
December
not on this
7th.
case, though. Those are separate cases. We're not talking about on this case, are
oh,
we?
to be clear, it's not on this case, but
Obviously not on this case,
Okay.
but the problem is that it keeps happening, and I can't continue to.
Sir, it's not keep happening, sir. Sir, this warrant that he said, sir, I went to court. I'm gonna be honest with you. I have another open case, and that open case is why I flew back down there. Went to court, finished court. They said I have a warrant. I go to the warrant district. They said I have no warrant. Leave the warrant district, get on the plane to fly back up here, and they said I had a warrant before I even flew on the plane back down there. So how could I fly?
To Jones, even if I were to set you a bond.
Okay, no problem. Hey, send me back there, man. Can't about this shit, man.
Easy money. There you go. Morning, sir. Sir, you're charged with unlawful carrying of a weapon. You are facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Shh. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 5th, 2025, the officer responded to a suspicious person with a weapon on 5900 Gulf Freeway. The officer made contact with the defendant, who was 17 years old. The defendant advised he was inside Jack in a Box while brothers were selling waters outside. The defendant saw a male rushing at his brothers with a knife, pulled out his gun, and pointed it at the male while telling his brothers to run. The officer performed a search on the defendant, locating a 9mm Glock 19, and the defendant advised he bought the gun from a friend for $150.
I mean,
Yes, Judge. In this case, the officer was going off the fact that he performed the search because he indicated there was a firearm. So
he's going to the defense of others.
yes, Judge.
It's another person.
And it's just the way
Yeah.
this is pled is because he's underage. He's below the age of 21. That's the way it's pled, Your Honor.
You hear this?
Hold on, I'm gonna go yell at somebody. Hold on.
Hi, Judge. Is this young man charged with unlawful carrying of possession for being under 21?
Correct.
Hold on, I've got a kit. Here's the DPS
But I'm
memo.
more concerned about the defense of others. Did you hear it? I mean,
No, hold on.
hold on a second.
Here's
Wait a minute.
DPS.
Let me give you a lawyer, Mr.
Yeah. Oh, I volunteer. I volunteer representation. Yeah.
Give me a record, can you fill that out? please?
I will do that. But here's a DPS memo saying that it's
on a second.
unconstitutional.
You know, represent the gentleman.
Oh, hell yes. Here's the Fifth Circuit saying that it's unconstitutional. Here is the United States District Court, Northern District, saying it's unconstitutional. Here's a motion to quash information. I'll just cross out the name.
Great job.
Yeah, I had to get in this fight yesterday and I'm teed up.
Oh, here you go, Mr. Tito.
Thank you.
Judge.
I was
is there
gonna,
PC?
yeah, look, you gotta be very careful, you know, God forbid something happens where you really dig yourself a hole. I'm gonna find no probable cause, but really, you have to be very careful. You know, sometimes you make a decision in life and it can really have consequences, all right? You know what that means, right? Are you in school? It all starts with school, man. You got to get back into school. This is not a good way to go through life at 7. The more schooling you have, the more money you're going to make. Knowledge is power, my friend. Do it. Make something. Make me proud. Please. You got it. It's going to get dismissed. Be careful, friend.
Yeah. Literally have all that on because I have a case in another court.
I was going to find no PC anyways. I wonder if he's named after Olajuwon. Are you named after Olajuwon? That's cute. All right, Miss Sir, you're charged with theft, aggregate theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 12th, 2025, the officer responded to an HEB in Harris County, Texas, in regard to the theft of an employee. The officer made contact with the complainant, the loss prevention investigator. The complainant stated the defendant was an employee of HEB, and the loss prevention employee was notified by a store manager that the defendant was taking Red Bull into the pharmacy without paying, drinking the Red Bulls, and then throwing it away. These acts were verified by video, and the complainant researched the defendant and noticed that when the defendant left his shift, he would have a bag of unpaid grocery items, would select items throughout the store, bring the unpaid items into the pharmacy, wait until the end of his shift, bag the products, and then leave the pharmacy without attempting to pay for the merchandise. The complainant observed the defendant take items without paying in 7 different days. The total was approximately $368.38.
All right. Sir, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go back to any HEB. Do you understand? If you violate these conditions, you pick up a new case, I'm going to put you in jail. No more PR bonds. You understand, sir? Are you working now? Do you have an income?
I am studying for my board exam. So no,
Studying for board exam for what?
actually,
Really? Not a good way to start, sir. You know, really. Look, I'll give you a lawyer today. Don't pick up any new cases. You got to understand that you got your future ahead of you, man. You want to be a nurse and now you got, come on, really? I need you to fill out an application for me. Fill it out. Let me take a look at it. I'll give you a lawyer today. Just make smart moves. It's not hard, you know, really. Come on.
Judge, was that response?
Yeah. Do you mind filing knowing back HEB, please? Any HEB.
Yes, Judge.
You were wanted out of another state. And I guess your lawyer there are two things. You're not happy with Anna here. And so we need to talk about number one. Number two, a lot of times when people have fugitive cases, they ask for me to set them a bond so they can get out and go turn themselves in. I don't know. I don't know why you're wanted out of the other state. All I know is that you have an open DWI now. And within the last, year and a half, you've picked up 2 other cases with me in this court. So I know you because you keep picking cases up. So I don't care if you have Jesus here. It don't matter who you got, where she's as that good, right? I don't know if I'm going to give you a bond because all I know is you keep picking cases up. And you're only 23. So Amy, tell me about Mr. Penn.
Yes, he's born out of Newton County, Indiana. The corrupt business influence, forgery, fraud, and identity deception. This was issued May 14th of 2024. He of course has local cases for DWI, 415. Let me see what else.
What's he wanted for? What was the first part?
Corrupt business influence, forgery, fraud, and then identity deception.
Corrupt business influence, forgery, and fraud. Do we know that they want him?
Yes,
Okay. Is there a bond that's been set there?
I don't have any information about bonds.
Okay.
Also, day is coming up in 5 minutes if we're discussing bond.
Okay. So tell me, what's going on?
Mr. Pena, I don't want to get too far into attorney-client
Sure.
communication. He would like to ask for a new appointed lawyer.
Why?
Well, me and her had a conversation, like, there's nothing against her, but we just had a conversation and well, I mean, I didn't think that
She's fighting for you?
you could
She's
say-
one of the biggest junkyard dogs that we have here. There's no one that fights more than she does.
No,
She's better than most attorneys I even see here. I'm telling you, she's amazing.
no, I believe you. You could be saying the truth, but
I am saying the truth.
no, I know you are. I believe me. And just off the fact, the case, the other price case that you did bring up, I haven't had. It was a year and a half already, and it's only been for my for protection. Like my other cases, I'm not no bad dude that robbery or they're all gun charges, and that's just on the behalf of the landscaping business that I got. That every time when I'm in the backyard or so, somehow they're always trying to steal the back of the trailer. That's the only reason, and the only cases that I got. I don't got no evading arrest, no like robbery or what, however you.
I don't know, but we have another prosecutor that's coming up to speak about this as well. I'm not going to give you another lawyer. This is a lawyer that we've given you. We only have a couple lawyers who do these types of cases regardless.
Okay.
So,
The only thing I was gonna, I'm sorry, I didn't mean to cut you.
Okay.
The only one I was gonna ask you was I was trying to get the lawyer that fought for the 2 gun charges. I don't know, Mr. Some with, I just forgot. I think he's an Italian dude.
those cases you had.
They have the same guy. And I really thought it was him right here.
Oh, it is Greg.
I know why you didn't familiar. Yeah.
Yeah, Greg, you represented Mr. Pena on both of his prior cases.
Oh, yeah.
Yeah.
Oh, man.
That's why when I looked at it, I was like,
So look, the only way you can have Greg is you can hire him. Otherwise, you got Anna. Okay?
oh, yeah, he's getting, oh, now he charges
Hire him.
that. Look at
I always charge. I don't know what you're thinking.
All right, we're going to put you back because we're waiting on another lawyer to come up here.
Let me go back and talk.
Yeah, for
I'll
sure.
charge you again.
Okay, hold on. Joseph,
Yes, Judge.
are you ready? Mr. Mukes, you're charged with resisting arrest, facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Please.
Thank you, Your Honor. A law enforcement officer was dispatched to a disturbance call on April 19th, 2025 in Harris County, Texas. The officer observed the defendant to be outside of the residence with what appeared to be an injured hand. The defendant stated he injured his hand while punching a wall when he was in an argument with his wife. The defendant stated that he had been drinking Crown and requested medical attention to the scene. The officer attempted to make contact with the female at the residence who refused to open the door. She only stated that the defendant should not be there at the residence and that she was in fear of the defendant. The defendant advised that he would leave the location and return at a later time. Later on that day, the defendant contacted Precinct 7 dispatch and stated that he was going to kick the door down at the aforementioned residence. The officers returned to the location and made contact with the defendant, who stated that he was going to kick the door down as soon as the officers left the location. Due to the defendant's apparent intoxication and the danger he posed to himself and others, the officers attempted to place the defendant in custody for public intoxication. The defendant became actively resistant and pulled away from officers while being escorted to the vehicle. The defendant told the officer, quote, "I'm coming for you," multiple times as he refused transport. The assistance of 4 officers was required to place the defendant in a patrol vehicle. The officer notes that the defendant actively resisted for 7 minutes and 13 seconds.
Mr. Mukes, I'm going to find that there's probable cause to go forward. Now's not the time. I know you're itching to say something, but look, I've got a bunch of prosecutors here. I don't want you to say something that hurts your case. Stop. Resist all attempts. If you want, I can give you a lawyer today and you can give your side to the lawyer. Okay. But right now, don't. You're only hurting yourself more when you think you're helping. Don't. I'm trying to help you here, Mr. Mukes. The only condition I'm placing on you now, you're not allowed to consume alcohol. Do you understand? If I find that you're using alcohol or illegal drugs, I will put you in jail. Just don't use. Okay? Do we know if she wants to have contact with him?
Judge, the offense date was on the 19th. We have not been able to reach out with the complaining witness yet.
So let's do this. I'm going to have them reach out. I want to know if she wants to have contact with you. If she's okay with it, then I'm going to allow it. Okay? Just don't. So we're going to try to do work on our side or their side to see if they can reach out to her to see if she's okay with contact with you. So let me see.
Morales Vega?
Okay. So, hey, do you mind reaching out to the Mac for Mr. Mukes? I'm going to get you a lawyer here pretty soon. I'm going to have you sign a reset with Victoria. We're going to have you take a seat in the jury box. Just look. Just don't. All I'm asking you to do, man. Okay?
I was the victim here and
I know there are two sides. Mr. Mukes.
I'm the one who called them for help and they locked me up and violated my rights.
Hey, Mr. Mukes, there will be video. We will take a look and we'll see because the evidence is going to point to whose side's correct. I don't know. I wasn't there. Stop. Don't. Please. First things first, though, is I have Mr. White that's been representing him. Right. And I guess, did I grant your motion withdrawal or we're having a hearing now?
We'll come back on
All
Monday.
right, so come on up.
So Will reached out to me on Wednesday. I spoke with Michael on Friday. I spoke with Michael on Wednesday. And so basically the understanding is that Will's gonna sub in and take over and I guess possibly resolve the case for today.
I'm hired onto this new felony case that triggered this whole deal. I've agreed to sub in on this case to work out whatever's going on here, and I've been talking to Michael about that. The felony case is bogus for a lot of reasons, but talk to the state about this as well.
Well, hold on.
Okay.
Putting the cart ahead of the horse.
Okay.
So you went out.
Yes,
okay. You're out.
Okay. And I'm in.
Well, I don't know.
Okay.
You want me to appoint him a lawyer or do you want to?
I'm taking it pro bono because I'm hired on the felony and we want to just resolve this DWI deal today, probably.
Well, because here's the deal. I'm putting him in jail. You picked up a felony while you're on bond for a DWI. You're not supposed to pick up any new cases. You've now picked up a felony and injury to a child, and it's just now coming to my attention, even though this thing's from November. I'm revoking your bond. It goes with you.
Which one's that? Okay.
Let's talk.
May I be excused, Your Honor?
Please.
Thank you.
Thank you, Mr. White. You did file a motion of withdrawal, correct? Mr. White?
He didn't file it.
Aaron?
Yes.
Did you file a motion to withdraw?
Yes, I filed it last week.
I saw it.
I don't have this one.
You said last week.
It's on Douglas.
I just see an appointment form from January.
I see the motion to withdraw. Yeah, it's there. Do you see it, Seth? Do you need a cause number?
Yes. I have the 2500939. Oh, no. Okay.
Yeah, can you put it in the queue so I can sign it? Okay, all right. Tell me. It does,
I know.
look, there's a certain standard.
I
You pick
understand.
up an injury to a child. I don't know anything about the case. All I know, he's picked up a 3rd-degree felony, and it's a serious charge. It's not like it's a
But, yeah.
trespass, but it's so.
But you know that these charges can be empty.
But I don't know that for sure. All I know is that he's picked up a felony. He's not done squat while he's on bond for this thing. He's literally been riding free, not doing anything for the last 4 months, 4.5 months.
Has he been blown in?
Nothing.
Nothing?
Done nothing. He's not tested. He's not had. He's literally done nothing. So, anyways,
State's offered a time served. I talked to Michael about it. I'm like, hey, my plan coming in was to try to get him back on PTI because
they're like,
the felony is so ridiculous. It blows my mind. But regardless, I was talking about that this morning. He's like, honestly, Will, he's like, the PTI it's not feasible for me to do. He's like, is there any alternative?
if you want time, take it maybe a day.
I don't need the time. He wants to time serve it today, Judge.
Well, if that's what he wants to do, then that's on him.
Okay. Would the court accept that?
Yeah,
Okay.
absolutely. I mean, look, far be it from me to, because that's what we would do in every case.
Right.
Any case that comes back here. And I mean, obviously, state, you need to also be happy as well, right?
Yes, Your Honor.
But it's on you guys. So I'm on board if they're on board.
Okay. I will run it by him just to make sure and then we'll get paperwork started. Thank you, Judge.
Mr. Douglas, you're charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. You know, it doesn't make me happy to put people in jail, but if you're a danger to my community, I only have one place for you. Do you understand?
Yes, sir.
You need to understand something very serious now, that this DWI is going to go on your record. It'll be there for the rest of your life. It's even there after you die. You get pulled over again, first thing an officer does, they're going to look at your record. When they see this and they look at the other, what do you think they're going to do? Think they're going to be happy? Think they're going to give you a hard time? Probably. So if you even have the most faintest remote smell of anything funky, it's probably not going to go well for you. You need to understand that from now on, it's a minimum of 90 days in jail. Do you understand?
Yes, sir.
You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, it will go on your record. You can never take it off. Do you understand? Do you still want to do this? How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
Is it true or untrue that you had a 0.15 or above? Okay, so true to the enhancement. You need to understand one more thing, Mr. Douglas, is that we all make mistakes, right? Everyone's human. But when you continue to endanger other people's lives, there are no more mistakes, they're actions. And when you keep making boneheaded actions, we have longer sentences, bigger jails, more fines. This carries a fine of $4,500. And if you don't do it, you sit in jail 1 day for every $100 you owe. So you can imagine how much jail time you will do on a $4,500 sentence. On a second DWI, it's a $6,000 surcharge. Get a clue. If you want to get lit, great. Take an Uber, $40, anywhere you want to go in the city. You understand? What do you do for a living?
Work at a warehouse.
How much money do you make a month?
I'm sorry. 16.
Look, I'm going to waive your fee for you today. You come back with another DWI, get ready, because it's just, do you understand? Get a clue. Good luck. Oh, I'm suspending your license for 180 days, sir. Do not drive until you get a license. All right, sir. Good luck.
Thank you, Judge.
Thanks. Is she here?
With permission, Judge, we've told them that. All right.
Okay.
If it's
She's
okay
got too
with the
busy.
court.
I spoke with her and she said it's okay for us to approach on the DVR, so I apologize for that.
All right, Judge, and just to distinguish where we're at, this was not an alcohol event at all. He's been.
I don't know that. How do I know that?
It reads.
I know that, but what in these instances, what happens is someone puts something in between the leg and in between the device to be able to subvert any kind of reading. That's what happens. So when you see something where there's no contact with the skin for a certain period of time, here it's 2 days, there's no contact.
And that's exactly why we're here, Judge. And I showed the prosecutor his leg, and we've been having issues with his whole entire leg is completely chewed up because of this device. It is.
But the solution is you come to court, you say, hey, I need to switch it to another leg. You don't just on your own initiative start sticking a piece of paper or a towel or something in there, you know?
Judge, I get it. I mean, just there's a tamper event doesn't mean it was intentionally done. And he's on GPS and he's
There's
on.
no way for us to know.
I
All
agree.
I know is that it broke contact with the skin for 2 days.
I agree.
Come up. I appreciate your tenacity, Mr. Leeper, but he has a DWI. He's got an FSRA where we have a dead body. He's not one violation. We're now working on our second to third violation, and now you're putting something, or I don't even know, but all I know is that the device lost contact with your leg for 2 days. That is unacceptable. When you have issues with a monitor, you bring it to your lawyer's attention, you come to court and you say, look, this is what's happening. You don't put something in there in hopes that we're not going to notice. And now you tell your lawyer after the fact. I'm sorry, Mr. Lee, but what choice do I have but to revoke his bond again? You know, I know that it's upsetting, but no, I have a very serious case with you. You've been ordered not, you know that there is no tolerance in this case. Yet, you lost contact for 2 days. I'm revoking your bond. Go to jail. Sorry.
What's his bond?
Mr. Leeper, I mean, I don't know. Judge, you know, I'm not getting through.
Well, this is the other side of it too. He can't switch legs. He's got a GPS on his other one. You know, he should have, I agree with you, this court, I agree with it, but something's good. We're gonna have to change something or even move him to like a full-time portable blow. Because it's not an alcohol issue, Judge. And, you know, he obviously made the mistake.
I don't know that, right? Until you come here and tell me, I don't know. The only thing I know is we have a DWI, we've got an FSRA, we've got a dead body, and I've got multiple violations. And now you're hiding, you're doing something 2 days that I don't know about. You know what the proper procedure is when there's an issue. And you're just not doing it. You do what you want to do. That's not the way it works. And now you go to jail. Goes with you. I'm sorry, Mr. Leeper. I can't continue to justify it.
Fine, Judge.
He does bond out. We'll craft a different solution. I'm all ears, but I'm not going to let him continue to subvert.
What's his bond set at?
10,002. I mean, it doesn't make me happy, but I have to let him know that I'm serious, you know, and you go 2 days, you don't have it. You've lost contact. I don't know what he's doing in 2 days.
This is the thing that frustrates me about these devices. He doesn't know he's lost contact. That's a whole, we don't get an alert saying that he's lost contact. He didn't know until this thing came in. And so it's on his leg. He's showing up to work. He's back home on time.
The device is snug to your skin. It's literally, it has to have constant contact with your skin. So for it to lose contact with your skin, there's something in between it, or they've done something to it. They've loosened it to where it's lost contact. They've put something in there. That's why it's impossible for us to know. The only thing that we do know is that it lost contact and it lost it for 2 days. You know? Yeah, if it was our first rodeo, if it was our first, you know, I always give someone the benefit of the doubt. But here we are over and over and over. And I've admonished him the last time, if you ever have any problems, you come to us. You don't do things on your own.
Thank you, Jeff. I agree, Steve.
I'm sorry, Mr. Lister. So, well, look, he'll end up bonding out. When he does, come back and we'll talk about it. We'll figure some solution out. My only issue is that if I give him a portable device, is he's going to start skipping blows. That's why we have this grant. But I'm willing to give him an opportunity to let the leg heal, give him a portable device.
Keep him on GPS and keep him on curfew hours.
Same thing, but I'm telling you, if I start seeing skipped blows, we'll have an issue. You know? All right.
How much was that?
10,002.
10,002?
Yeah. Given a rating?
Yes, it's for Blake Jenkins.
Okay.
And Judge, I showed up and he is wanting me off the case. He wants a new attorney.
Jenkins, come up, please. You have Gibson, huh, Sean? We'll do that next.
I think I've got Jackson. Yeah, Jackson.
Hey, no talking. Speaking of, why don't we get some out and start signing conditions, we'll get them out.
We're waiting on bond conditions.
All right, let's get them out.
Judge, this is Jenkins on page 14 and 15.
I'm signing conditions so we can get some people out of here, please.
You signed those remote strips.
I did. Okay, so why are we here on Mr. Jenkins? What happened?
Yes, he was on bond and there's a new offense, so we're here for an arraignment. And then,
So he's on bond for 2 cases. He's now picked up a 3rd case. Is this right?
that's correct, yes.
Mr. Jenkins, you now stand charged with the offense of reckless driving. You are facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On January 12, 2025, at 6:26 p.m., the officer observed the defendant's vehicle traveling at a high rate of speed on a feeder road without headlights on. The officer checked the speedometer and it read 80 miles per hour while the defendant's vehicle was traveling faster. This occurred in a 50-mile-per-hour zone. The officer observed the defendant's vehicle make an unsafe lane change, cutting off a motor vehicle and reaching a speed of 106 miles per hour with moderate to heavy traffic. The officer observed another unsafe lane change while attempting to catch up to the defendant's vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle.
Mr. Jenkins, I'm going to find that there's probable cause to go forward with the case. Does he have a valid Texas driver?
Yes, eligible.
I'm now revoking your bond on the other 2 cases. You will go into custody with me because you picked up a 3rd case, sir. Goes with you.
Judge, he also is wanting me off the case. So I didn't know if we wanted to address that.
I'm not going to talk to you about this case. You have a lawyer. You need to talk to the lawyer.
Talk about my two cases before that, sir.
I'm not going to talk to you about this. We'll put you in back if you want. I can give you a new lawyer today. I'll give you a lawyer, another. If you want to get off, and I'll provide you another lawyer. It's the 3rd case. Unacceptable. So we'll take you off and we can appoint another lawyer on all 3.
Lyra?
Yeah, James.
Right, Judge,
No. Give me a second. So, 5,003 on the old cases, please. Are any of you here with parents today?
No, sir. No, sir.
None of you came with any parents?
No, sir.
Mr. Gallegos, you were charged with discharging a firearm. Are you Who's Gallegos?
Right here, sir.
Mr. Gallegos, you were charged with discharging a firearm in a metropolitan area. You are facing up to a year in jail and or a $4,000 fine. Are you Mr. Gamero?
That's me.
Mr. Gamero, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. Mr. Garcia, you were also charged with discharging a firearm in a metropolitan area. All of you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You each have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On January 12th, 2025, the officer observed 4 males in dark clothing forming a circle and discharging several high-caliber weapons into the air while on patrol behind a residential neighborhood in Harris County, Texas. The officer observed 2 males run towards Muscatine Street and 2 males flee towards Garber Lane, where the officer remained stationary. The officer identified the second male apprehended as Defendant Gamero, 18 years old, who was found in possession of a Glock handgun tucked into his waistband. Defendant Gamero admitted that he and a co-defendant, a 14-year-old juvenile, had been firing an AR-15 and a Glock along with 2 other males who fled with a second AR pistol, and the other 2 males were apprehended, one of which was Defendant Gallegos, 17 years old. Defendant Gallegos confirmed the other male's identity and stated the weapon had been passed around among 4 individuals and that all were involved in shooting them, and that the AR was purchased from an unknown individual in the street. The 4th male was identified as Defendant Garcia, 17 years old. Defendant Garcia admitted to firing all 3 seized weapons, and Defendant Garcia was observed disposing of an AR-15 and surrendering.
Gentlemen, I'm going to find that there's probable cause to go forward with each of your cases, and I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. How old are each of you? How old are you, sir?
17.
How old are you?
17.
How old are you?
I too.
What do you do with yourselves?
Well, I just be at the home with my girlfriend.
Did you graduate from high school?
No, sir.
We're going to work on that. Did you graduate from high school?
No, sir. I'm so great. Yeah.
Are you currently enrolled in school?
No, I had dropped out, but
Okay, not anymore.
yes, sir.
We're going to work on that. What's your situation?
I'm currently enrolling in school because I just left and
No. Are you enrolled or are
No,
you
sir.
not? Okay, we're going to work on that as well. Did you graduate? We're going to work on that. The first thing I'm going to tell each of you is that you are not to smoke any weed. I'm sending you each for a test right now because I want to know what, if anything, is in your system. If there's something in your system, you will get a pass today. But I'm giving you notice now that you will be retested in 45 days. And if I find that you continue to use, I'm going to put you in jail. I don't know if you're using, but if you are, it stops today. And if you stop today, in 45 days, you will be clean. If you continue to use, you're going to end up staying with me. Do you understand?
Yes, sir.
What goes up must come down. So when you fire a gun in the air, a bullet has to go somewhere. If it lands on a 7-year-old's head, what happens? It's a rhetorical question, meaning that you don't need to answer. But I'm giving you something to think about, that what goes up must come down. What goes down will ricochet. And if it ricochets into a person, someone's going to get charged with that murder. Do you understand?
Yes,
There
sir.
are proper places to do these things. That's what you do. As far as I'm concerned now, none of you are to be in possession of any weapons whatsoever. Don't worry about filing any conditions because each of them are going to be honored. I will provide each of you guys a lawyer today, and I'm going to send you for a test. You must come back. If you fail to go test, if you fail to come back, I'm going to issue a warrant for your arrest. Do you understand?
Yes, sir.
Okay, take a seat for me, please.
Right this way.
Or I'm going to have you sign resets and then we'll have you take a seat.
Chris? Get first.
This is not a good way to start in life. I can tell you now that if you don't have a high school diploma, you will make pennies to when everybody else is making dollars. You will never have a good job in this life at a minimum without a high school diploma. Knowledge is power. And if you don't set yourself up for something in the future, you're going to end up destitute. 90% of the marriages that are end up in divorce now is because people have no money. They fight constantly because they never have money. And it all starts now when you're 17. And it starts by staying in high school. I want you to do that. I'm going to bring you back in 2.5 weeks. I want to see what you have done to get back into school. If you need help, I can give you resources so that we can sign you up for free GED classes. Because I don't know if you're old enough to get back into high school, but if you want, I can give you resources now so that you can start with GED classes. That's fine with me. One more thing, no smoking weed. I will test you 45 to 50 days from today. If I find that you're smoking weed, it's not going to go well. You get my drift.
Yes, Your Honor.
If you stop as of now, the next time I test you, it should be negative. If you continue to use, you understand?
Yes, sir.
You must stay in touch with Ms. Oakforth. She'll tell you how to handle this case and what you need to do. If she tells you that you're playing games, I'm going to put you in jail. No more PR bonds. All right? Do you understand?
Yes, sir.
Good luck, man. Make me proud. Come on.
Judge, can I ask a question before we're done? Mayor, Counselor.
Miss Young, come on up.
Good evening, morning.
Don't look at his computer.
Sorry, I was trying to get the time from him.
How's jail?
Evening. Sorry.
How's jail? Shh.
Treating us beautiful.
You know, we can't get you to come. We can't get you to appear.
Well, what happened was this time?
No, but there's always an excuse. It's really easy to just pick up a phone and call Josh. How hard is that? You know, that's all we literally ask you to do is remain in contact with your lawyer. That's all you got to do.
Yes, sir.
We've repeatedly tried 4 different times. Your lawyer's asking me to let you out to get in this program, but I know if I let you out, you're just going to
No, sir.
take off.
I'll do the program. That's not the problem, sir. Honestly, with the phone situation, that's how he has a whole different number since last time I came. I don't even have that number anymore. And with the transportation part, I don't have a car. So the way I move around is either using the bus or my feet, sir. And last time that I did come, I came on my own. No one told me to come. No one called me. I knew I ended up missing it and I came.
Unless you're wearing orange. That's the only time we see you.
No, sir, I turned myself in. I came in myself after I missed my court date and I came in by myself. I can't give you a date, but if you look on there, I sat here and waited till everybody even left.
Guys, did she turn herself in or she got arrested? Can you tell? If you turn yourself in, that would make me very happy. But if you just got arrested and that's why we have you?
No, sir, I came to court.
Young, she's on the jail doc. Last page, I think. Fool me once, shame on you. Fool me twice, shame on me.
I'm not trying to fool anybody, sir. Are you able to look that up for me?
It's okay, yeah.
Okay. Is it on there? Because it was like 2 days. Yeah, like it was 2 days after my court date. I came. No one called me. I just knew I missed it. And I didn't have a ride, but I made sure to get up there because that's how I got my date reset the first time.
Looks like the booking date was the 12th, Judge, but I don't know. That's all I can see from my side.
That's when I came to 12. I've been here since.
Where did you come to?
Sorry?
Where did you go to? Did you turn yourself in the jail? Is that what you're saying?
Sir, I went to the Franklin Street, if I'm not mistaken, Franklin, 1200 Franklin, where all the court is at. Where I was supposed to go the first time. 1200 Franklin, if I'm not mistaken.
It was on Sunday, though. Was it over the weekend?
Honestly, I don't even remember what day. Oh, this time? Yes, sir. I can't.
Let me, you know what we could do is we could do this, is that if we're going to do this, you know how we do that release that we release to people? Something like that. So we know that she gets to the P180 place. Where is it? Where did they do the interview? Do you know?
I guess because it's not like an inpatient facility, would it be different if it's?
Where does it happen? Do you know? Do you know where the interview happens, Josh?
I'm not sure like physically where it is, the P180. I'm checking the state though. Because I guess she wouldn't be released to that program. She'd just be released and have to.
Do you have a date already for it? Do you have a date for it?
There's like a way to book it online, but they said that you have to send a contract to PTI, P180 contract. So, which I think is what we have now. So I think we should be able to schedule it now.
Okay, so let's do this. Schedule it, get a date, and then I'll put a GPS monitor on her prior to release. I'm not going to do this again. You ever take off on me again, I swear on everything that's holy, that'll be the 5th time. Do you understand? So I'm not giving you a PR bond now to just wait, get a date. We'll set it for like the day before, and then we'll give her a PR bond with a GPS prior to release. The instruction is she goes directly to get the interview done, and then we'll go from there. But I'm not going to continue to play this game.
But I'm not playing a game, sir. It's been cold. Like, what do you expect? It's been 20 degrees, sir. 20 degrees. You know how hard that is to actually stay.
Your fingers so frozen that you can't make a phone call?
Sir, I just got the phone. That's what I'm telling you.
If you need resources, we can give it to you. If you need a phone, if you need a tablet, if you need food, we have resources to give you. But you take off, you don't call, you don't come to court. So what are we supposed to think? And we just can't keep, I've got 4 different times. I can't continue to do the same thing.
We'll get the schedule.
All right. Do it and we'll see. Okay.
The one you, Ron Barnby was in jail in Fort County.
Oh, we reinstated? Okay.
Here today because you wanted to bond conditions.
Good morning, Mr. Barnes.
Good morning.
Sorry, David.
You made it out.
Yes, I did.
Just, we're not asking for much, man. Just be careful, behave. Don't do anything you shouldn't do, you know? Is those cases are still open in Fort Bend or what?
The case is still open in Fort Bend. It's still pending. Your next court date is down there.
It's on March. Not all the cases are open.
One of them still open. Paul Two's representing him. I talked to Paul yesterday, and it's set for sometime in March. I can't recall the exact
It's okay.
date.
Have we done PC on this yet or no?
We haven't done anything because he was in custody.
Right. Okay. So we're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. I just want to see if there's enough to go forward on your case. I don't know what happened. Okay, Alex, please.
Yes, Judge. On September 4th, 2024, the officer observed a hand-to-hand transaction between the driver of a parked vehicle and another individual. The defendant was a passenger in the vehicle, and the officer approached and smelled a strong odor of marijuana. The officer asked the defendant to step out of the vehicle and saw in plain view a scale in the driver's side door, and the officer detained the defendant and the driver. The officer found a bag of marijuana in the defendant's waistband pursuant to a pat-down, and the weight of the marijuana was 1.27 ounces.
Telling me he saw him do a hand-to-hand transaction or someone else?
The driver of the vehicle was a hand-to-hand transaction, and when he approached the vehicle, he asked the defendant and the driver who did the hand-to-hand transaction to exit. And furthermore, the officer smelled an odor of marijuana.
I know, but why would he search him?
What?
I get it on the driver because he sees the hand-to-hand contact with them, but he's just sitting there.
The only thing would be officer safety, just the pat down. That.
All right, Mr. Barnes, I'm going to find no probable cause. Just be careful. All right, really. You hang with dogs, what happens? No. Well, you get fleet. Well, you can get bit too, right? Please.
It's a bad dog.
Just don't hang out with the wrong people. All right. Come on.
Christopher.
Thank you, Honor.
Mr. Oates, you were charged with harassing communication. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Judge, on August 29th, 2021, an officer was dispatched for a stalking call. The complainant stated that the defendant and she were previously in a dating relationship but had been broken up for about a year at the time. The complainant stated she had to block the defendant's number because he was calling her excessively. On this date, the complainant witness noticed that the defendant's location was close to hers, which freaked her out because the defendant had moved to Oregon. She also stated the defendant left flowers at her house and had told the defendant about 10 times to leave her alone via text message. The defendant refused to and said that he just wanted to talk to her. The defendant stayed outside playing witness's apartment all day and watched her. The defendant took a photo of the apartment and told the complaining witness to come outside. The officers detained the defendant. The defendant admitted to calling and texting the complaining witness numerous times. The defendant had sent over 80 text messages, which the complaining witness stated exclusively.
So if I'm going to find that there's sufficient probable cause to go forward with the case, I'm ordering you as a condition of your bond, not to have any contact with this person and not to be possessing any weapons. Do you understand? Now, where have you been for the last 4 darn years?
So when I got out of jail, after my posted bail, I went back home to Oregon and and I started my life again and I just gave
It doesn't
up.
work like that.
You know,
You go to jail.
and I understand that. See, when I was here, the lady told me, she was like, what are your intentions when you get out after bail? And I was like, I'm leaving. I'm not coming. I'm not going around her. I don't want to
Have an open case and you can't just take off and go to Abu Dhabi because you want to take the hell off, start a new life. No, it doesn't work like that. Appoint him a lawyer, please. Take a seat for me in the jury box.
I'm here on Mr. Osis. He's the gentleman that found out he had a warrant and walked in. I am here asking if you would reinstate.
Come up.
His previous comment.
No, sorry. No, he's been gone for
So
3 years.
if I may, Judge, when he was originally arrested at magistration, the magistrate asked him what his plan was if she let him out. He said his plan was to go back home to Oregon, and she said, good, do that and stay out of trouble.
Are we supposed to take what he says at face value now?
And Judge, he also has had no contact with the police for 4 years because he's had this warrant since 2021.
Did we look? Did you do an?
There's no FBI number, Your Honor. Let me check his state ID.
Do you need it?
I have it.
Okay.
Yeah, but because he had the warrant, if he had contact with the police in Oregon or Georgia or South Carolina,
Where are you living now, Mr. Oates?
I live in South Carolina with my 2 best friends. One of my best friends is trying to get me a job with the construction.
Not now, while this case is open.
Well, I know, and that's how I found out about all of this, because I took my drug test and my background check, and they said that they couldn't hire me with an active case. And so as soon as I found that out, I called the court, and I couldn't get through, but I kept calling, and I finally got through. And then I told your assistant or one of your assistants that said as soon as I get enough money to travel down there, I will be there. I'll pay my bond, and I will take care of this case. And so as soon as
How old are you?
27, sir.
So what are you doing?
Right now, I work for Dick's Sporting Goods, as in the process of trying to get the job as a construction worker, as a pipe fitter.
Okay, I'll reinstate, but I'll put a monitor on his ankle.
Okay.
You take off again. I'll never do this again. I'm not giving you another PR bond.
May I ask you a question, sir?
Sure.
So I do live in South Carolina. Am I allowed to go back? I can give you all the information. So I have to stay in
This
Houston.
case is from 2021. It's now time to take care of it.
Okay. So I have
You know, really, do you have an offer in this case now?
Not yet, Your Honor. We have spoken to the complainant. Being that it's so old, being he's coming in on a warrant, we can reach out and get a quick reset so we can talk to the complainant again, see where she's at.
And
Go from there.
Judge, we would ask for a 10-day trial setting.
Your Honor, that's just.
I mean,
I know.
It's his fault that he's gone. I'm not
Yes.
going to blame the state because of it.
That's unreasonable.
No. Right. No.
I apologize for that.
Do you see how many problems it creates?
Yes, sir.
Really,
I do.
You're supposed to live and you sign paperwork reflecting everything. So you need to read every single thing that you sign because there are consequences when you do whatever the hell you want to do.
Yes, sir.
All right. He gets an ankle monitor today. I'm going to reinstate his bond.
Okay.
So I'll give you as much time as you need,
Okay.
whatever you guys, but this case,
We can do a quick setting, Your Honor.
within 30 days, it's player trial. I'm not giving you more than 30 days. So
We'll talk about
you
it.
talk to her.
Yes, sir.
She'll explain everything to you, but this case lives and dies within the next 30 days.
Hi, good morning, Judge. My client is Michael Jones, and he's in custody, and he's asked me to argue probable cause for him, and so I
Sure,
shall.
of course. You ready?
Yes, Judge, does he need to be brought out, or do you, I don't know your process.
Mr. Jones, please. Yeah. It's only fair, right? Because it's his case, so.
You didn't hear me.
It's only fair because it's his case, so we might as well bring it up.
No. He asked me to do this, and so I told him I would.
Yeah, this is Michael Jones.
Yes, Michael Jones.
Okay,
That's my client.
he must be unhappy, huh?
Asked him to breathe.
Or hungry.
Asked him to breathe.
You said Jones, right? Michael
Yes,
Jones?
Judge. Michael Jones, 254-6980.
Good morning. How are you? If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay? Okay. What happened?
On January 10th, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
No.
Just losing?
So, Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then...
Right, but then cops get up there.
And then they observed him begin to walk away, and it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and...
Didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know
says...
about that?
And
Yes,
aggressive
Judge,
behavior.
but
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. "I smell marijuana. You look intoxicated," because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, "We identified ourselves as police," so what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, "I'm the police, stop." We don't live in that kind of society. "I'm the police, I need to investigate you, so therefore stop," all day long. "I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter," all day long. But hey, I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So
a criminal trespass.
They're called, yes, a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So the trespass investigation ceases because he's leaving.
Right.
Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is? The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred to determine,
He's leaving.
He's walking.
He's leaving, right? It's like, here, let me come and mess with you more.
That would only.
Right? So it's like adding fuel to a fire.
But they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw, him refusing to leave, and he
leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't be, it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm going to find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we? You don't like to wear orange, do you? Be careful where you go. Be careful what you do. Everyone's always out to get you, man. Don't let them. All right, man. Good luck.
Thank you.
Unless you.
I didn't hear what happened.
She said you'll be.
Thanks. Counsel, how are you? What's new?
On anything? I heard something about.
Yes. Yeah.
Big Van Halen fan.
I am. He's my hero.
A Van Halen cover band.
Was at one point in my life, not anymore. Just, kids have got me riled up. I don't even have time to go to the bathroom by myself.
I went to was beg, borrow everything I had to do, and finally parents broke down. Somewhere between 7th and 8th grade, I went to Van Halen's 1984 tour.
Wow, you saw him in 84. Wow. That's amazing. Was it, how old were you?
I was between 7th and 8th grade, so 12, somewhere in there.
Was it amazing or what?
Yeah, it confirmed my heterosexuality.
It was the biggest, oh yeah. They were known for their shows, just the debauchery and just.
It's still, to this day, it's still just, it's just another level of
And I'll tell you, the earlier you go with their shows, the raunchier they were, right? But by that point in 84, they're so big and, MTV had just come into play, right? So their videos were just now coming out that they got so big that like all the eyes were on them and the newspapers were coming out and saying how the shows were so debauchery, right? And so that's when all that censorship started coming up, when, David Lee Roth is testifying, about being against censorship and this and that. And so I think at that point, they probably maybe.
The whole, what was it, the Parent Music Resource Center with Tipper Gore and all that. Yeah.
Yeah, that's awesome, man. Yeah, there's, on YouTube.
I play too. So
On YouTube, there's one video of 1984 that they have the entire concert from beginning to end.
Seen that.
And it's amazing.
It's just, I'm just shocked that there's not more like high quality footage.
They wouldn't, Noel Monk wouldn't let it.
Shows that come out recently, like 81, and I saw 79 show that came out with, and they re-upscaled all the videos, so the video quality was a lot higher. But just this week, I think on YouTube, Dweezil Zappa shared some alternative, what was an alternative? It was a live performance that he knew about where it was pre the release of Fair Warning, where Eddie's doing basically an alternative version of the Mean Street intro.
Really?
Concert, yeah. It kind of combines that, the little tap, that, with it, which he kind of incorporated into his the guitar solo, like later on.
Wow.
I play guitar, bass, keyboards, drums.
That's awesome. I tell you, it just, I wish I could have been, my folks are just too, they would never, and I was just too young.
You a Mammoth fan?
I'm sorry?
You a Mammoth fan?
Yeah. I haven't listened to much of it.
Telling you, second album is phenomenal.
Really? I haven't heard it. I'll check it out. But he's a lot different though. He's more like, is it Tool-ish,
Well, he's kind of, it's everything. It's like Meshuggah meets the Beatles with some Tool thrown in on some things, but then real catchy pop songs.
I'll have to check it out.
And
I have not heard it.
live, oh my God, they're so good live.
You saw him?
I've seen them 3 times now.
Wow.
Every time they get in here.
Let me know next time if he comes to Houston, because I think the last time did he not come here or did he come here?
Talk about some heavy duty touring. They've been just touring nonstop.
Yeah, that I know. He's been an animal.
We're opening up for Metallica and Pantera on stadium tour. I saw him open up for Alfred Riggs the first time. They were just on the Creed tour. I drove up to Fort Worth to go show, not to see Creed, but to see Mammoth. They came out and just destroyed. I've got you're busy right now, but there's a song, oh my God, oh my gosh. Okay. I'm like totally blank.
Is it Mammoth or what?
Song, it's a guitar solo in this song that's oh my God, I can't believe I can't remember the name. As soon as I see it,
Yeah, show me. So do you want to talk to me while we're waiting?
Yes, sir.
Show me.
It's called Take a Bow.
Check it out.
It's on the second album, Take a Bow, the guitar solo. How nice is this? He's recording everything at 5150. Uses his dad's original Frankenstrat guitar on that song.
I've heard that. Yep. Awesome. I'm gonna check it out. Thanks.
See you later.
You are on bond for murder, and you've now picked up an assault case. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Thank you, Your Honor. On April 27th, 2025, in Harris County, Texas, officers were dispatched to a disturbance/unknown weapon call. The complaining witness stated she is part of the nursing staff and that the defendant has been asked to leave on multiple occasions and refuses to do so. The complaining witness stated that the defendant was attempting to get her grandfather to sign over power of attorney to her, but the staff would not allow this due to the grandfather being diagnosed with dementia. The complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the defendant put her hands on the complaining witness's face and pushed it back. The defendant was positively identified by the complaining witness and her Texas ID number.
You say that there was any pain? She pushed in the face. This is an assault, right? There has to be some kind of injury or pain.
She did state that she felt pain in the dim summary.
Okay. Ms. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. Now, you're saying there's a bond violation in this case?
Yes, Judge, it's still the.
Michael, have you seen this? And how did you already get appointed to this case?
Your Honor, I was appointed sometime very recently on this case. I received a text. I don't know what day it was, but I received a
It looks
text.
like it was the 29th, which was Tuesday. But how was he appointed a lawyer?
I'm thinking when she was in the holdover.
No. How is she, I mean, I don't understand. Well, regardless, I guess I'm glad that you're appointed because right now she's got bond violations. She was
I
ordered by the
wasn't aware of
magistrate.
that, Judge.
I'm sorry?
I wasn't aware of a BVR in this case. I actually have another BVR today before the court.
I know that, yeah, we got you. We'll deal with that one next, but you're on bond for murder. You were ordered by the magistrate to have a GPS monitor. You have violated those conditions. Unacceptable. I'm revoking your bond. She goes with you. No.
Your Honor, if I may,
Yeah.
Your Honor, she just was released because I met her in the holdover earlier this week, and she could not have been out of jail more than a day, two at the most. Would the court allow her to leave right now to get the device?
No. Did she not get the device?
There was a conflict, that's why the DVR was submitted, felony, so the magistrate ordered bond conditions, but the curfew times were not aligning with the felony conditions.
So what? I mean, you still have to abide by the conditions. I mean, what did they say the conditions were?
I have the paperwork right there.
I'm not asking you to say anything, Ms. Taylor. The only thing I want is I want my city protected. You're on bond for this serious case, and now you picked up an assault. I mean, you were ordered to have certain conditions. You must abide by these conditions.
And Your Honor,
She received conditions of bond on April 28th, 2025 that ordered a GPS device with a curfew of 7 p.m. to 7 a.m. On May 1st, she had an unapproved enter at 7:52 p.m. and then left again at 8:51 until basically 9 o'clock at night.
Yes, Judge, and on the felony conditions, I'm looking at them right now, their curfew is from 12 a.m. to 6 a.m. So that's where it's conflicting. So the magistrate ordered from 7 p.m. to 7 a.m. and on felony, their curfew was 12 a.m. to 6 a.m.
I mean, she still has to follow conditions, right? There may be conflicting, but you abide by the conditions and then you come to court and you ask to, do something or maybe make them align, but you just don't do whatever you want to do and think, okay, nothing's going to happen. You're on bond for 2 serious cases.
Your Honor, if I may again.
Sure.
This is a brand new case. Could the court admonish her? Because the amount of time, I understand that.
Michael, she's on bond for murder. She's lucky to even have a bond, and now she picks up an assault. She's ordered to have a curfew, and she's just doing whatever the hell she wants to do.
In this case, Judge, that's before your court. This is a brand new case, and this is her first time having any issues while on your bond, Judge. Would the court be willing to admonish her not to leave her home even for short periods of time?
I don't know, Mikey. I don't know.
And my assumption is we're going to reach out to Melanie. My assumption is there's a BVR call for that too. So I don't know what talking to her looks like, but.
I don't know, Michael. I'm going to stew on it for a while. You
Yeah,
want to
sure.
talk about your other BVR? Or wait, hold on a second. Sorry, let me just finish with the arraignments. Give me 2 seconds and then we're almost
No
done.
problem, Judge.
Next one, Judge, is page 2.
I expect that you will comply with the bond conditions. And when you don't, there are serious consequences. As a condition of your bond, you're not to consume alcohol or illegal drugs, and I'm going to randomly test you. I also don't want you to have contact with the co-defendant, and I don't want you to go back to this nursing home. It's not an answer. The other gentleman that got arrested for the same exact thing.
That's my brother.
Okay, I don't want you to have contact. I mean, do I not have to tell you how you're on bond for 2 serious cases now? And it's just I'm going to protect my city at all costs. I don't care who you are. Just if I find that you're a danger, I'm going to revoke it. I'm going to make it sky high. Do you understand? Yes or no?
Yes.
I'm going to test you within the next couple of weeks. Don't use. You must stay in contact with the lawyer. If he tells me that he cannot get a hold of you because you're ducking and dodging phone calls, I will issue a warrant for your arrest. If you pick up a new case, likewise, I will revoke this bond and I'm going to make it high.
That's fine.
For now, we'll have you meet with Roxanne to get your bond conditions and then we'll let you go.
Your Honor, the felony court has a curfew that allows her to work. She does DoorDash. The curfew upstairs is from midnight to 6 a.m. because she does DoorDash in the evening. Would this court let its bond condition?
Curfew is what time?
Midnight to 6 a.m.
She's allowed to drive from midnight to 6 a.m.?
No. She stops driving
So the
11-ish.
curfew is from 6 p.m.
No, from 12 midnight to 6 a.m. is her curfew in the felony court because she drives at night. And she stops around 11-ish.
On her license to see if she has a license. So you're telling me that she can be out from midnight? What hours do you work?
Home by midnight.
Yeah, I have to be in the house by midnight.
Yes, Your Honor.
Judge, it's a different page that typically comes up. This says suspended.
I never had a license in Texas. My license is from North Dakota.
They're showing it's suspended.
Shouldn't be. I paid all my reinstatement fees already.
Take a look, Blaze, please. Can you help us out? Just to make sure. Especially if she's door dashing.
Yeah, we're seeing driver's license, non-commercial status suspended.
Say it again?
It says, driver's license, non-commercial status suspended.
The license is suspended, man. You're not allowed to drive. I'm telling you, they're looking it up and they're telling you it's suspended.
Right.
Yeah, I mean, for us, it says suspended. I mean, if there's
Okay,
anything-
you're not allowed to drive. If you want to drive, get the license reinstated, and we can take the condition off. If you're,
I've already took care of it, so maybe you just haven't updated, but I took care of the reinstatement already.
just don't drive. If you drove here, you're not allowed to drive home. I'm sorry. Your license is suspended. And then before you also drive, you must maintain liability insurance as well. So don't until let us know. I'm making it a bond condition that you're also not allowed to drive when you get it. Or if you get it reinstated, if you get it fixed, come back, let us know. We can take this condition off. All I'm asking you to do is follow the law. I'm not asking you to do anything, Pythagorean's theorem or anything. Just follow the law. Don't be a danger to my city. That's all I'm literally asking. Really. We're going to have you sign a reset with Victoria. We'll have you meet with Roxanne for your bond conditions, and then you're free to go.
Your Honor, currently she has 2 different curfews in 2 different courts. Would this court mirror the felony courts
She's not going to be working now. She's not going to be working at night now. And she's got a very serious open felony case. She's not picked up an assault. I'm not going to let you be out at night.
That's
No.
not the only reason why I had the curfew though. I have kids that have after school
But
programs.
you can't do this stuff. You don't have a license.
Everything doesn't consist of me driving. That's not why the only reason why they mirrored that. I share literally everything with my mother. So she helps me get my kids back and forth to school. She helps me get my kids back and forth when it comes to their after school programs and things like that. She lives on completely the opposite side of town. So every time we try to do everything, I'm never gonna make it in the house by 7 o'clock. That's the whole reason why they extended it.
Okay, look, I'll give you till 10 o'clock at night. Okay, just be home by 10. That's it.
And of course, getting the kids to school in the morning, I think that's why they
Yeah.
get 6.
I'm okay.
10 to 6,
10
Judge?
to 6.
Thank you, Your
I'm
Honor.
okay with that. Just don't be a danger to my city. That's all I'm literally asking. Okay?
I'll get your recent date in a minute. I got one more person.
Okay, thanks.
Hey, Judge. I'm approaching on a fugitive case, Mr. Francisco Martinez.
Okay.
I'm going to grab one right now, Your Honor.
Got it.
We have the interpreter here, Ms. Celeste. This is one where I think they arrested the wrong guy, so he's going to be released. The only issue is this might pop up in the future, so I don't know if where he gets the
not me letter. He has to go to the demanding jurisdiction, that's the judge, or it could be the prosecutor assigned to the case saying that this is my face attached to this government name. I have a different FBI number, whatever they want to pick. I don't care. But, you know, because it's the same date of birth, so that's going to be irrelevant for the not me letter.
Are you how do you know? Did you do
Tattoos and FBI number and mugshots.
Okay.
It's a common name, and I
Yes,
guess
it's a very common name.
I guess common-ish date of birth.
Ish? Or the same date?
But no, it's same date of birth. It's just we had one happen last week, so 2 in 2 weeks is kind of unusual.
Yeah, I would say so. So you're definitely going to file a nollie now?
I already filed the dismissal.
Okay. So where is it that he goes? I don't remember.
where is it that he goes?
To get that letter?
Jurisdiction.
Yeah, that's the thing. I
But
think,
where? I don't even remember.
Illinois. Wait, sorry?
Oh, yeah, that's where he's from. It's-
That's where he had to get it from.
So he's gonna have to go up there.
Right.
Where though? Is it at is
Will
it
County?
no, is it at a sheriff's office or?
No, it's gonna have to be by the court or the prosecutor, because they're the ones attached to the case that they're going for, because ultimately it's the warrant. And if the warrant's recalled, it makes it all irrelevant, but.
Morning, Mr. Martinez. You have a very common name and there are a gajillion Francisco Martinez's out there. There is an unfortunately, there is someone wanted in that jurisdiction that has your name. And you see now that you've been wrongly arrested, you're going to be released today. The fear is that this continues to happen. So I don't know, there are methods out there. And Mr. Kim, you say there's a letter that he can get.
Yes.
What we're going to do is I cannot give you legal advice, but I'm going to have your lawyer that we've appointed to represent you tell you how you can take care of this so that it doesn't happen again. So we're going to process you out. You should be out within hopefully the next 4 to 6 hours. Ricardo will tell you how to go about getting a letter so that this doesn't happen again. Do you have any questions? Did you want to add anything, Ricardo?
What's there to say, Judge? It's just a bad situation. This man was arrested for this, it's not him.
Yeah.
It's not a good situation.
Yeah, I mean, mistakes have been made. And I don't know, I guess the arresting officer, I don't understand why they wouldn't do just a little bit deeper dive is.
Well, when they're on the field and it's obviously an arrest in the evening, is us being one of the few agencies that's truly 24/7, is that they can only confirm by teletype for whatever the fugitive division is. And so with it's most commonly name and date of birth, and statistically that should narrow it down, but it's just,
I mean,
because you can't take, or you can't send.
Have mobile apices?
For that when they get processed in, but that only brings them in for, again, the same name and date of birth, but you can't trade mugshots with the demanding jurisdiction. Because the teletypes can't support images. And so ultimately it's only what the text is, and that text is the name and date of birth. So.
On that sense, Judge, would his fingerprint goes with.
That's and that's why I was, they've got these mobile aphises that.
The mobile thing where they could just test him and see if it's his prints or not.
Sure, but the majority of warrants, the way they're sent by teletype, again, a thumbprint can't be imaged in a teletype.
I got you.
So even if, so yes, there is a thumbprint, but there's no way to.
The thumbprint should be able to verify who this person is, whether they have the correct date of birth,
But
mug shots.
But that only corresponds to the warrant for the demanding jurisdiction if they have something to match it against. So that's the issue is, yes, it can pull it up on our side, but it's the same way even for our parole violations is they can't check on scene, especially at 1 a.m. That's why we're the second check, is that we're able to verify if there's a thumbprint, mugshot, etc.
You're going to be released here momentarily. I'll have Ricardo tell you how to take the next steps though, okay? All right, good luck, Mr. Martinez. Thank you.
I think we still need to approach on a different one from Mr. Diaz. We'll approach soon.
Yeah, I'm gonna just call their main line since the sergeant's not getting back to me. It's like, I'll find it.
February, you have a terroristic threat with us of a family or household member, and now you've picked up an evading arrest in a motor vehicle. While you're on bond for this case, you pick up a serious third-degree felony. What happened in a terroristic threat?
There's a threat, Your Honor?
The terroristic threat in our case, please.
In our case, on February 3rd, 2025, an officer responded to a weapons disturbance at a residence in Harris County, Texas. The officer met with the witness who stated that her granddaughter's boyfriend, the defendant, was upstairs in the house with a gun. The witness stated there were 5 other people in the residence and everyone exited the residence safely except for the defendant. Officer met with the witness who stated she had been dating the defendant for 3 years and broken up with him hours before, and the defendant left the residence. When it was asked the defendant if he wanted to retrieve some items, and the defendant said no. The defendant came back to the residence, and the complaining witness refused to let him in. Short time later, the defendant sent the complaining witness a picture of him inside her vehicle, pointing a handgun at her bedroom window. The complaining witness saw a laser through her bedroom window, which she knew was attached to a handgun that he owned. The defendant threatened to kick her door down and make forced entry into her home. The complaining witness still refused, and the defendant began hitting the windows around the house and screaming the complaining witness's name. The complaining witness called 911 and went inside a different bed.
Something out of a movie, like a horror movie.
A second witness, the uncle, led the defendant inside the residence because he was unaware of the break-in. The defendant went straight into his room. The officers tried to make contact with the defendant but were unsuccessful. The defendant was identified by a photo and date of birth.
So tell me what happened now in the new, please, in the evading.
Yes, Your Honor. On April 2nd, 2025, a law enforcement officer was dispatched to a vehicle in reference to a discharge of a firearm. While searching the neighborhood, the law enforcement officer made contact with the witness who advised that the driver was a Hispanic male with light bushy hair, and the vehicle had a plastic wrapping around the rear window with one laminated tail lamp. The law enforcement officer continued to search the neighborhood and observed a vehicle that matched the description. The law enforcement officer made a U-turn and pursued the vehicle. As the law enforcement officer approached the vehicle, the driver accelerated speed and disregarded a stop sign.
Tell me they found a gun.
The law enforcement officer do not have that vehicle. The law enforcement officer initiated lights and sirens to stop the vehicle, failed to stop, failed to stop, accelerated speed, and disregarded multiple stop signs for approximately 3 minutes, and around 1.5 miles of roadway, reaching a speed of 62 miles an hour. There were multiple areas the defendant could safely stop, and the defendant stated he evaded because he believes he had an open warrant for family violence. I
Is
believe
this in warrant status? Do we know?
if this wasn't warrant status, Your Honor, let me.
It was a 2B, Your Honor. It wasn't, it was a 2B that was filed. It wasn't so I think they're speaking about the terroristic threat family violence in our case. And it was filed as a 2B. He never was arrested on it or didn't have a court record.
You know, Mr. Arroyo, you need to think that in this world, when you go to jail, you now know you have no one that's going to pony up money to get you out. So when you go to jail on charges, you are stuck unless someone's, right? Since January, you've had an unlawful restraint, an assault of a family member. Now you have these two open cases. Why would we continue to give PR bonds?
If I may, Your Honor, the two previous cases, the unlawful restraint and the assault family member, the file date was back in 2023. He had it set for a jury trial and it was dismissed. He never bond forfeited.
You represent him on those cases?
I did not. I was just appointed today to him. But I'm just looking at the procedural posture of the case. He does not appear to be a flight risk of any kind. He took those cases and.
Well, I mean, he's evading capture now with the police, you know? Something's going on with you, man. I don't know what's going on, but who do you have in your life? Who's around to give, our mom, dad, who do you have? You got a son? What? You're a baby yourself. How, I mean. Do you live with mom?
I live with my mom.
Well, that's what I'm asking. Who do you live with?
I live with my mom.
Do you actually live there or are you out on the street all the time?
No, I actually do live there. I stay there and I take my sisters to school in the morning and pick them up after school. And I work and I take care of my son every day that I can when I'm not working. And he sleeps over if I'm not going to work the next day. That's all I'm really doing. But
in the last couple months, you've had 4 charges. What do we need to do to ensure you don't pick up a 5th?
He is now living with his mother. It sounds like before he was staying with the complainant. So the change in location is going to be helpful, certainly. He now has employment. He works at Cosmic Air.
Let's do this. If you can, is mom here? No.
I don't believe
No,
so.
so let's do this. If you can verify that she will actually take him, because I'm not giving you a PR bond or even a bond reduction for you to just go out on the street. If I let you out, I'm putting you under very strict rules. No dope, no alcohol, and I'm going to test you like crazy. Does he have a license? You're not allowed to drive. I don't care what you got to do. I don't care about your little brother having to go somewhere or your son. If you don't have a license and you don't have car insurance, then no driving. That is a bond condition. I'm going to have you sign an affidavit promising me. If I find that you do, I can have a contempt hearing an additional 6 months.
Sure.
But I'm not letting you out unless you have a stable place to go to, because I don't want you out on the street. Nothing good. And I'm giving you a curfew as well. You understand?
Sir.
I'm going to put a monitor so I know where you are at all times, and then we'll talk. But first things first, not to the street. If you can verify that he's got a place, then let's talk. And I'm happy to do something.
Thank you.
Yes, ma'am. Yes. Okay. Joe. That way. Guys.
Thank you, Judge.
When they get older, it's.
We got Mr. Morris, Mr. Robinson.
Morris and Robinson. Good morning, guys. All right, so tell me what we're doing with these gentlemen.
We're reading extradition on both of them, Judge.
Okay. So. Mr. Morris.
Yes.
Oh, you say Mr. Morris's.
You are wanted out of the state of Louisiana for failure to register as a sex offender. Are you waiting for formal extradition?
Yes. Hey, Judge, I have a question.
Shoot.
Since the charge originated out of Harris County like 40 years ago, since I served time here since in the state of Texas, they've been trying to make me sign up for this in Louisiana.
So what this is it looks like they filed a charge out of Louisiana, right? And they issued a warrant for one reason or the other, probably a failure to appear. It could be just a new warrant that, Dave, do you have any
My best guess, because I don't have the underlying offense, but the originating offense that required him to register as a sex offender did come from Harris County, but they might have had some evidence that he either resided there or had an appearance in Louisiana.
Perhaps it got transferred over there.
Right, and so for some.
Or no, I mean, that wouldn't work.
But-
I don't know. I have no idea. They give us so limited information here on what the underlying case, we don't even fight the underlying case. All we do is establish who you are and whether you want to fight extradition or not. Really. And you are Sydney Robinson?
So Judge, on Mr. Robinson, we'll have the waiver on the fugitive case. And then on the assault case, if you wanted to put bond conditions, I believe state wanted no contact.
Oh, music. So you're on bond for an assault here out of our court here. You were also wanted out of Adams, Colorado for driving under the influence, failure to display proof of insurance, and careless driving, and
I know, Judge. I know, but it's on there. It's one of the warrants.
low power scooter operation without a license.
Which is completely false. It was a Harley.
Don't, really, just waiving formal extradition on that case, right? Okay, so I don't know anything about are you representing him on the assault?
I am.
Wonderful. Alex?
Their cause number for the
Assault?
Yes.
254-7113.
I apologize. 254-7113.
113.
Okay,
CBD though.
that is correct. Let me see. Okay, I can tell you the facts of the case, Your Honor, if you
Okay.
want to hear those. So on the assault, the officers were dispatched to a welfare check at a residence in Harris County, Texas, in response to a disturbance. The caller, the witness, was met by the officer, and she said she kept hearing the female saying, "Stop it." The complainant stated she went to an upstairs bedroom and slept, and that the defendant entered the room, grabbed her by the throat, and lifted her off her feet. The complainant stated she did not have pain or impede breath due to the fact that she was very intoxicated and could not feel anything at all at that moment.
Did you say she was very intoxicated?
She was very intoxicated at that moment. And then on the morning of the incident, or on the 11th of January, the defendant woke up and they started verbally arguing again. And the complainant said that the defendant threw a box at her and hit her in the head. And the complainant said the defendant began to chase her in the backyard. And while she was in the corner of the backyard, the defendant ran towards her, threw her down in the mud, and began choking her with his hands. And the officer observed the complainant to have fresh bruising around the left eye and a red marking on the left and right side of the forehead.
Okay, Mr. Robinson, I'm going to find that there's probable cause to go forward on your assault case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. I'm also ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? Okay, so the other thing is this, Shreya, is that he's on bond for this here.
Right.
What, do we know that Colorado's coming to get him?
Yes. So short answer is yes. I haven't heard anything else since the original.
Okay, so we need them to sign conditions. Now, you got to be aware that if you go back, if they end up picking you back and you go to Colorado, whatever happens there, you must remain in contact with Shreya here, because if you don't, we're going to issue a warrant here. And what's happening now will exactly happen over there, where you're going to be sitting in custody over there. And then a hold is going to be placed over here. And then you're going to have to come all the way back over here. All you have to do is remain in contact with her so we know what the situation is going on. And don't have any contact with the complaining witness's case. Don't pick up any new cases. Understand? Yes, sir. Okay.
And Judge, in case, for whatever reason, Colorado decides not to extradite and he is released in the next week, we're going to do a appearance required for the January 29th.
Okay. That sounds good to me.
Okay.
Okay.
Was there state conditions, Your Honor?
No, pre-trial. Josh.
The chief on it,
Is she here?
He's here, Judge.
Great. Shall we get it done?
So she's not accepting any offer, and I think they're gonna be refiling as a felon in possession case, essentially. The state's gonna be dismissing this case, so that's my understanding. Richard?
I'm.
So
Can you bring her up? Can you bring her up? I'm so sick of playing this. This is just.
This part.
I'm sending this for trial right now. I'm not taking anything. I'm tired of this game. If she ever shows up at 1 p.m., I'm going to hold her in contempt. How long when can we get this trial?
So Judge, here's, I know we were going back and forth with this too. Sorry, I looked at this. You can look at it today. I think it's clear. I think it's strong. And even more so strong. So
Are you gonna? What are you gonna do?
I'm feeling grand jury today. I'm gonna try to get the grand jury.
They have given you an offer in this case. By you rejecting it, he's telling you now he's gonna go to grand jury to have it indicted as a felony. And you're gonna be looking at a 3rd-degree felony. You realize this. You want to set this thing for trial? Or what do you want to do?
I'm fine.
That's fine.
Okay.
I'm gonna get email grand jury today.
You were set for trial this Tuesday and you showed up at 1 p.m. If you do that again, I'm going to have a contempt hearing and you'll be facing an additional 6 months in jail and a $500 fine. Do you understand me? When you were set for trial, you were to appear here at 8:30 in the morning, not 10:02, not 11:51, not 2, 8:30 in your seat. Do you understand? So how long, what's the soonest trial setting we can do? In the event that you don't get it indicted, because
I just asked for 30 days just so we can get all this things out. And all that. I mean, actually, it should have been done already, but we look, just, I don't want to put either Cole or John in the spot.
okay, so this will be set for trial May 20th. I'm sending you now for a drug. Did we send it for a drug test yet?
I believe you did on Tuesday, Judge.
Sent her on Monday, I believe, and she was for something positive for THC and coke.
Okay, I'm revoking your bond. You're going to custody right now. She goes with you. Unacceptable. And now we set it for trial May 20th.
Everybody call.
5001. Yeah. Over and over and over. And I don't know if that's what it is that's causing everything in all these cases. But I have a sneaky suspicion that it could be due to all that. You now tested positive for cocaine, fentanyl, what else?
An alcohol, Judge.
Alcohol. You were on bond for 5 different violent cases. Goes with you. I'm sorry, Mr. Portillo. What I would like to do, because obviously now we now know that there may be a more substantive issue that may be causing all this. So what I'd like to do is have him TRAS to see how we go forward. But I'm not going to just continue to take these cases where we're basically pleading guilty throwing him in there 30 days, gets out, he picks up another felony. We have now 4 or 5 open felonies? No. I'm not going to continue to perpetuate this revolving door of you picking up a case, getting out, picking up a case, getting out, picking up a case, and now you're testing positive. No, we will now get to the root of what the problem is and why you have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, now 15. It ends today. Goes with you? We'll have him to your ass. Let's see what it says. And then, you know, but I'm not just going to continue to do the same thing in hopes that when he gets out. So, send it for Tiraz. We'll come back in a couple days, get the report, and let's see what they say on how it goes. Okay. But I'm not going to just continue to do the same thing and hope for a unicorn because it's just not going to happen. You know?
I would like to just.
It's up to you.
I would like, I mean, if. Right.
Let's figure out what's going on.
Sure. I just want to see what I mean,
Sure.
obviously as his attorney, I need to see what his options are and meet with him.
And I don't want you to do anything you are not kosher or not happy with, you know? Before we do anything, you know, of course I want your blessing. And if he says no to what they say, then we just go
Have a
try.
try.
And we'll go one after the other. Just be ready, please. Okay.
Should we, I guess, set him like for Friday or something and see, I don't know.
It's probably gonna be the process today. I don't know if tomorrow.
You know, there's no way. It's now 11:30. Till tomorrow, he's still gonna be processing. Right. So we can't start the TRAS until he's out. Latest will probably be Wednesday is when we get it done. I would say we probably will have the report.
Well, but he'll be set for bail review automatically, right? For Wednesday or?
But if he stays in holdover, somebody can come over there.
We usually have people come here to do the TRAS here.
Right, okay.
Here, to
Okay.
try to expedite it so that they don't sit there for a week or 2 weeks, you know, because we want to, it's not the idea, it's just to hold, just for the sake of holding, is to get everything done quick so you guys can make the informed decision quick. And we'll see, you know, and the idea is hopefully he's honest and then try to get to the cause because,
The options.
you know, before there's a murder case because he's using and he does something that's irreparable, you know?
I
I
understand.
mean, how many times have we seen it? So, okay.
Thank you.
He had picked up a new case, no PC, state dismissed, but the new case involved him possessing, though not using, a kitchen knife. And so the bond conditions.
I didn't ding him on it, did I?
Well, you had asked us to come back today to address the fact that he had.
Oh, right.
Kitchen
That
knife.
he had the knife, correct.
Yeah, so not that he had potentially committed a crime, but that he had a kitchen knife when he was ordered not to have a weapon.
Guys, I need your help. Come up, Mr. Lidon.
And so
Come up, Mr. Franklin.
when you informed me this morning, I think I'd been sent the email, there's a bond violation report for a GPS exclusion zone. I looked at.
So I want him so he can.
Yes, Judge. I'm gonna stand between the state. Yes, Your Honor, no, Your Honor, arms by your side. Whatever he asks you, answer truthfully but briefly. Keep your response brief and do not get excited, okay? All right. Yeah, let me get all this out of the way.
The initial reason that we were here today was because of the case that you picked up that I found no probable cause and that I had an issue because they were alleging that a knife was, I guess, allegedly in possession or whatnot.
The allegation is possession. It was never, there was no allegations of use or threat. It's just that he had a kitchen knife on him.
You are on bond for a terroristic threat. As part of your bond condition, you had several. You're not to be in possession of any weapons. You have a GPS monitor, and you're not to go within a certain boundary of the complaining witness in this case. It has now come to my attention through pretrial services that you have bond violations. Specifically, Mr. Franklin has not been compliant with his conditions of bond. Client has failed to not have contact with a prohibited person or visiting a restricted location. Client was ordered by the court not to go within 500 feet of the Northwood Drive apartment in Baytown. On 2/25, client received a victim exclusion zone alert at 10:22 a.m. The victim exclusion zone was cleared at 10:28 a.m. In fact, what I've been told by pretrial is that we have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 instant.
Okay, interject, Judge. I think that's all in a 6-minute window. So I think he crossed into the exclusion zone at 10:22 and out at 10:28. And so I could proffer to the court what was given to me from pretrial. Not that I'm admitting.
Judge has a copy.
Then never mind.
I got it.
In no way admitting that this would be admissible. And looking at what pretrial has provided, it looks like he walked about 1,000, maybe 1,500 feet in about a 6-minute window through the exclusion zone. And while it says contact, there's no alleged contact with any person. It's just, I know, but it's the way it's written.
How do we know?
Well, no one has complained to the state. And so it looks like he walked through an exclusion zone, which is, speaking with pretrial, is actually larger than it normally is. I think it's at 500. Is it 500 feet?
At 500 feet because I didn't want him to go anywhere near the complaining witness in this case.
Yes, Judge.
This is the same complaining witness that we have the last case that I know PC'd?
No, the two are unrelated.
They are different complainants.
Yes. And so the terroristic threat they're both strangers. The terroristic threat is, the allegation is that my client asked to bum a cigarette, got in an argument when he was denied. And then the newer case with no PC was that some random person's window was broken and somehow my client got charged with it when no one saw or had any evidence to believe that he had done it. But when the police made scene, he then had a kitchen knife, I believe, is the allegation. I will say that the new case, it was no PC, but there's also no evidence. There's no offense report, there's no videos, because it's a week old.
It's because they didn't go get anything, because I know PC'd it.
Well, that's part of it. It's also Baytown.
But the problem is that we continue to have issues with Mr. Franklin.
So Mr. Franklin is going to have issues on bond or not, Your Honor. His mental illness is quite severe. He's received hospitalizations in the past. His orange sheet is right at a page, if not over. And so the system is aware. I would take this court or ask this court to take caution in the sense that we're not having a formal hearing. There's no testimony presented. I'm fine with having a conversation. But if the court should wish to revoke
We're
his
having
bond,
a hearing right now.
well, then nothing has been admitted because there was no admissible evidence. I'll find to discuss with the court what has been alleged, but there is no admissible evidence of either location or possession because nobody has testified to either. And I don't think the pretrial services officer in this room would have the ability to testify how a GPS device works. Not to be mean to her, but it's not her job. And so she's not going to have any knowledge of the firsthand knowledge of the device.
We continue to have issues with Mr. Franklin, and I'm tired of it. I'm not dealing with this anymore. I only have one way to fix this.
So I've spoken with the state, particularly the chief. We're leaning towards reaching a resolution on a mental health diversion, Judge. It's not 100% that we're there, but it sounds like we're going to do it where we send him for an evaluation. So I'm going to file a competency evaluation just in case. But
so that there's another 30 days. I'm not going to sit here and wait for him to have another bond violation. No, because he's doing whatever he wants to do, because that's what's happening here.
Yes, Judge. And if you'd like to revoke his bond, which I can understand the court's position, I would just ask that we have a formal hearing with testimony where the rules of evidence would apply, which statutorily they would apply to any revocation of bond.
I'm still going to take him into custody. I find that he's a danger to our community. He's continuing to just. Mr. Franklin, what am I supposed to do? Continue to let this happen?
For me, don't farm. I ain't getting no justice.
I found no PC on your case last time.
I ain't getting nothing to nobody.
All I'm asking you to do is stay away from this place.
what I'm supposed to do. I'm trying to take care of my nieces and nephews, running back and forth to the store and stuff. What I'm supposed to do? What you want me to do?
If you need things, we
I
can.
don't, all I'm doing is the best I can. I'm not doing anything to nobody. What you want me to do? I didn't have nothing to do with none of this.
Listen.
You ain't
I want
stopping
you to
nobody from
listen.
raping me.
Just slow yourself down, okay?
Is he saying that
He's insistent.
family that lives near here?
So he's given me, I've been trying to get addresses. So he lives partially with cousin and with mom, who are both on this side of town. And he essentially migrates between the two. Because of his mental health issues, I'm having a problem confirming the addresses to confirm this information.
Where are you staying?
My mama's house, but she threw me out this morning. So it's the same thing. She pulled a pistol on me, yeah? Trying to tell me to shut up and let her say whatever she want to say. Switching up everything, making it hard on me.
Does your mom live near this address?
She stay down Nolan. When I leave, when I leave, I don't have nowhere to go. I go to my cousins. I buy them food. I do the same thing I
The
do.
problem is that are they within this address?
They stay down Nolan in Bay Terre.
No. Baytown is a big city. I don't want you to go near where the complaining witnesses live. That's all I'm asking you to do.
But I was just having to go to my oldest cousin's house and my mother-in-law's house, get food, and then go get my
Here's what I
medicine.
want you to do. I want you to talk with Mr. Meunier right now, and I want to know exactly where they live in relation to this address. That's what I want to know. I'm
my mother's
debating
address?
to put you in or not. All I want to know is why. Because I've asked you not to go to this place, and yet, no. I want you to talk to your lawyer, and I want to figure out where the places are where your mom lives, where the cousins live, so we know exactly where you can and can't go. Do you understand?
Yes, sir. I can
go.
Thank you, Judge. I've been trying to get the addresses and it's somewhat difficult, but we'll give it another try. Be right back.
Mr. Mannix?
Commissioner Approach again, Judge.
Yep.
I think I have the location figured out. It took a while because getting addresses from my client is difficult.
It's okay.
So, let me just visual aid. So the exclusion zone.
No. Don't. Just take it off because I'm live streaming. I don't want to.
Oh, okay. All right. So if you were to look at the exclusion zone, numbers 10 and 19 are just left of it. That is the cousin's house. So he lives probably 30 feet outside the exclusion zone. And so my client.
So hold on a second. Saying.
So
13.
So numbers 10 and 19, because I have the ones I have are numbered.
I see it. 10 and 19. That's that
So
cousin.
That, from what I can tell, is the cousin's house. I'm having to do this with Google
What about
Maps.
number 24?
Well, no. What I'm saying is that's where he's kind of living. He then walks through the exclusion zone. Mom's house is about 2 miles due east. This one, he's actually, I think he was walking to CVS to get his psych meds. And so he goes through the exclusion zone to get to Garth Road, which is the road that the CVS is on, which is just outside the map. I can show you on my phone if you'd like. So he walks to Garth and then goes north up Garth to get to the CVS and then east to Mop. So I think this 6-minute window, I think is him walking through the exclusion zone to get to CVS. As far as I can tell, that's what's going on. He never stops very long. It's a 6-minute time. It's
CVS in relation to this.
So in relation to the map, if you keep going east of the map, maybe half a mile.
I don't understand the curve.
That's him trying to walk around the apartment. He was trying.
He's right next to it, man. It's like literally within like.
He's going to get his psych meds, Judge. Rash thinking is not 100% level. He's trying to go around it from what I can tell. Well, I don't know, Judge. I think there's a big field, and I think he's trying to go around to get to the field, to walk through the field. But CVS is. Here, let me just show you my phone. That'll be the easiest. So.
No, but come around, because I don't want to live shit.
I don't want to do this without you. A stranger who was supposedly threatened, I mean, I think I would be annoyed and scared.
Franklin, come up.
Okay.
I want you to understand something and listen to this clear. I want to protect every person in my county, and I want them to feel safe. This person is scared of you. That's why I don't want you near them. Do you understand, Mr. Franklin? All I'm asking you to do is stay away, because I don't want you to accidentally bump into them on the street. You guys exchange words, and then it goes absolutely haywire. That's what I'm trying to prevent. Do you understand? It's not to be mean to you. It's not to take away this. I'm a nice person. I don't like to put people in jail. But if you're going to be a problem and you're going to scare my city, I've got a problem with that, and I'm not going to take it. You understand? So CVS, where you're trying to get to on that map, is nowhere near where this person lives. Your cousin lives outside of the area of the zone of exclusion. Look at me. Mr. Franklin, there's no reason for you to go near where this person lives. You need to find another way. I'm not going to do this with you again. Do you understand? I'm trying to be nice to you now, and I'm trying to warn you that I don't want you to go near anywhere where they live. If you need help, Nathan can help you out. If you need a place to stay, we can find you a place. If you need food, if you need a job, we have resources we can give you. All you have to do is ask. But
He can't give you a job. He can tell you where to go to try to find you.
But I want everyone to feel safe. Do you understand? That's all I want.
Oh my God.
Like I want you to feel safe. That's it. Here, everyone gets a fair shake. Everyone. I found no PC on your case last time, right? That's a fair shake. It doesn't get any more fair than that. Do you understand? Mr. Franklin, I'm well within my right now to put you in custody. I'm not going to, but I want you to understand that I'm not going to do this again. You understand? I'm not asking much. Okay? All right.
Thank you, Judge.
So just please make a path for him to go around so that there are no more issues.
Your Honor, I was going to see if we could shave some of the, I think it's 500 feet, and the cousin lives just outside, and it looks like GPS is giving some false positives. I was going to see if we could lower it to 400 instead of 500.
The dean was for the cluster in the center, that would be 200. The same would be a.
Okay. All right, hold on a second. Are you saying that the circle is within 200?
So that circle's within 500, but it was originally at 200. And so he was deemed for being within 200 feet.
But these right here are
Yeah,
not.
so that's gonna be outside of it. So he's not being deemed for those. They show all the points that is being used.
Yep.
But that's not a violation.
Okay, then we're, all right. I have a caution because it's right outside the zone, but it sounds like it will be okay.
Just make sure that you guys can carve a path so that there's no more issues.
Yes,
Okay. Okay. All right, Mr. Franklin, that's it.
You have a seat, okay? Now you can sit in this pew right over here.
For Billy Chapman. Mr. Chapman, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On February 10th, 2025, at approximately 2:08 a.m., the officers were in a parking lot of Reno's Bar responding to a disturbance that had occurred at the business. While conducting the investigation, they heard a vehicle rev its engines multiple times, and the officers went to check on an individual inside the vehicle, but before the officers could check the vehicle, it took off at a high rate of speed, recklessly in the parking lot, and the officers called for an additional unit to search for the vehicle, and an officer responded. The defendant's vehicle circled the parking lot and returned to the scene, where the calling officer was able to initiate a traffic stop. The officers observed a strong odor of an alcoholic beverage and red glossy eyes. The defendant was placed into custody for public intoxication due to a miscommunication between the officers, and it was later determined a DWI investigation was needed. Standard field sobriety tests were conducted, HGN 6 out of 6. Walk and turn was attempted, but the defendant could not stand in the starting position and was constantly swaying. For the one-leg stand, 3 out of 4 clues were observed. The DIC was read, and the defendant consented to breath. The results were 0.154 and 0.149.
What was the stop for?
So they responded to a disturbance and they heard a vehicle rev its engine and he took off at a high rate of speed. So then they attempted to get it reach that vehicle because it took off in the parking lot from what they described a high rate of speed recklessly. And then it came back and then they make
traffic infraction. High rate of speed is conclusory as well.
Because initially they said the officer said he observed and heard an individual revving their engines, and then they were attempting to check. They were attempting to check inside the vehicle, and that's when it took off at a high rate of speed, recklessly in the parking lot, as they describe it. And then the vehicle circled the parking lot.
All of that is conclusory. All of that.
And I understand, Judge. And unfortunately, we do not have the OR at this time, so we can, if you give us a moment, we can see if there is an applicable traffic infraction.
Yeah, I mean, I'll give you a little bit of time.
Yes, Judge.
But can you give me maybe 30 minutes?
Yes,
We can
sure.
revisit.
I'm going to run somewhere else. I'll be right back.
Okay, take a seat,
Thank
please,
you,
sir.
Judge.
We'll be back with you here momentarily. I'm going to find no probable cause in your case. You have to understand, they give out DWIs like it's candy on Halloween. Do you know why? We lead the nation per capita in fatalities with alcohol-related collisions. Don't become a statistic. One button on a phone, one button, $30. An Uber will take you wherever you want to go. Use it. All right, take a seat. All right, thank you.
This is Trajan Edwin, Judge.
Okay.
Trajan, I'm sorry.
Good morning, Mr. Edwards.
Edwin.
Oh, Edwin, I'm sorry. I'm on my fault. All right, so Mr. Edwin, you're charged with evading arrest or detention. And criminal trespass. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 21 days in jail on the evading credit for 7. Is this what you want to do, sir?
Say that I'm getting out tonight.
Yeah, it's time, sir.
So time serves is very sexual to me. Thank you so much for it.
But you need to understand, this is going to go on your record. If you run from the police again, they can charge you with a felony offense. Do you understand?
If our Salveria toll licenses does not want me to get in trouble like this again.
I didn't hear.
Salveria toll licenses does not want me to be acquitted and being in a judge face like this again.
He's saying somebody doesn't want him to get in trouble again like this.
You know what we're doing today, right?
Today is the lawyer's offense of licensing me to get out of jail, yes, sir.
Well, you're pleading guilty. Is that how you understand it?
Well, I'm not necessarily pleading not guilty, yes, sir.
Are you guilty?
I am fully registered to be guilty.
What happens if you pick up another evading arrest?
You are resourceful and knowing to not do it. So we don't.
What do you say?
He said we are resourceful to knowing to not do it.
Okay, don't. You can get a felony next time. You understand? All right. You're giving up a lot of rights by doing this today. You don't want a trial. You don't want to talk to witnesses. You need to understand that there are consequences. It will go on your record. It will be there forever.
Just be like Salveria Toll Licensors. I am just be like I am the CEO of Salveria Toll Licensors, which means I am a lawyer.
Let's
understand that.
Let me reset him, Judge.
We do not want to get in trouble.
Let's go back.
You're saying we do not want to get in trouble.
I want to make sure you understand, Mr. Edwin.
No, it's not done. We need to talk. We kept talking.
Mr. Edwin, We just need to make sure you understand what's going on. Okay? You know that you're pleading guilty to this offense.
Yes, sir. Yes, sir.
Do you know what that means?
Taking convictions.
Right. So you know that this charge will go on your record, correct? If you run from the cops again, you'll be facing a felony charge. You understand that? Okay. You also need to understand that by pleading guilty, you are giving up many rights. You don't want to go to trial. You don't want to talk to witnesses. You don't want to confront, cross-examine the people who are accusing you of this offense. You give up the right to appeal. Once you plead guilty, you can never change this. Do you understand? One more thing is that if you're not a citizen, they can deport you, exclude you from the country, or deny naturalization. Once you plead guilty, you can never change it. Do you understand? Okay, how do you plead to the offense of evading arrest or detention? I will find you guilty. I'm going to follow the agreement. Be careful. Don't run from police again. Okay? All right.
Good luck to you, Mr. Edwin.
Look, Mr. Edwin.
You're getting out today. All right. Thank you, Judge.
Thank you, Warren.
I'll follow this one out.
Okay, coming up, man. How's Jen? Really? It's good? Fun?
No, it's really not, but I'm blessed to be alive.
Well, that's a good attitude to have. That really is, because it could be a lot worse. You could always be 6 feet under, right?
Right.
Your lawyer is asking me to set you a bond, but I'm really concerned. This case is very old, and you've been out literally. She's been on the lam for 10 years, Dave?
Well, the warrant was on November 9, 2015 for this one, Judge. But the surrender for the judgment roll was on, well, actually, the enrollment date was February 16th, but the surrender notice to file was April 2020. So I don't know what kind of efforts they went, but the actual forfeiture date was in 2015.
Do you know, do they really want, are they going to
I
come?
mean, that's like with the other ones, I can only confirm the initial teletype confirming that the warrant is valid and they do still want her.
We've tried to reach out to, I'm sorry, Mr. Kim has tried to reach out to the demanding jurisdiction to see how serious of a case is it? Are they really going to come back? But he's been unable to reach anyone. And I mean, it's only been, 30, 45 minutes. So, your lawyer's asking me to set you a bond. Because of the nature of the case, the type of case it is, and because of the age of the case, you're asking for.
Your Honor, the state's asking for $10,000 because it is a possession of controlled substance with intent for oxycodone and the fact that it's been in forfeiture status since 2015. This isn't one where it's a 2B warrant. It's one where she appeared in front of a judge, stated she would return, and then she didn't do that.
You want
$1,500, Judge. My client has expressed to me that she is a college student. She has expressed to me that she only works for, because she's in school, Uber and DoorDash. She has expressed to me that she has an attorney that is working because she doesn't want this behind her. She can't have this when she graduates in May, if I'm not mistaken. I have explained to her the ramifications if this court was to give her the bond, that she has to that attorney either has to get her a date set there or she has to go turn herself in within the 14 days. She does not have any other criminal history or connection or contacts with police that were dismissed or otherwise, except for this one case from 2015.
The thing is that I have to set your bond sufficiently high so that you understand that we mean business. I'm not going to play this game with you again. If I set you a bond, it's only going to be one time. I won't do it again. You need to understand that there are serious consequences with the actions that you take now. I'm going to set you a bond. I'll set your bond at $5,000. And if and when you make bond, we give you 2 weeks from the date of your release to go turn yourself in to that jurisdiction where you're wanted from. Mr. Kim, where is it?
It's in Mississippi, Harrison County.
So you have to go turn yourself in. If you fail to do that, I will revoke this bond. I'm going to set it at 0. I will issue a nationwide warrant for your arrest. Obviously, I mean, you can't run forever, right? We're going to get you again. And this time I will physically hold you until Louisiana comes and gets you. Do you understand?
I do, Your Honor.
Okay.
So just knowing that, he has made the bond for $5,000, is that something that you can, or you or your family is able to post? Because if not,
5,000 cash?
it's 5,000.
Oh, no, I have a deaf baby. I'm a single parent. My husband died 3.5 years ago. I'm on a fixed income. That's why I do DoorDash, and that's why I do Uber on the side, just to help,
So I said that to say that the waiver, if he sets the bond, then the waiver goes away. They don't come and get you. You don't get to have the bond and wait for them at the same time and see which one happens first. So if you're not gonna be able to pay the money, then you can, the option is to leave the waiver that you have in place that you signed on, I think 2/27, and then let them see if they're gonna come get you or not. But your time, you don't lose the time that you've already been in custody.
So when you buy, I'm confused, when you behind,
What did she waive?
Right off the bat, 227?
February 27th.
So you have 1, 2, 3, 4, 5, 6 days credit. We give them 14 days to come get you. If they don't come get you within the 14 days, we release you. They file a dismissal, I sign it, and then they let you go. If that happens, the warrant will always remain active. And that warrant will always remain active until you physically go back or somehow go back to Louisiana and take care of it. That said, if you want to make this bond, you have to withdraw that waiver that you have, and then you lose those 6 days. So if you withdraw it and you don't make the bond, you lose all that time, and you basically it's told until you re-waive or you make that bond.
I only say this because of the nature of the case and the fact that I didn't know she had counsel in Mississippi. It's very, very rare, but I have been seeing it happen here and there, is if local counsel there can get a new setting date. Like I said, it's incredibly rare. I can count on one hand the amount of times it's happened.
What do you mean, get a new setting date?
So even if they don't appear with sufficient evidence, the Marsh Sheriff's Office says she's in our custody and her persons is here, and for a variety of factors, I can't speak to Mississippi because I'm not licensed there and I don't work there, is whatever sufficient factors they have to set a new date for her to self-surrender versus outside of the fugitive, they will recall the warrant. So like I said, it's incredibly, incredibly rare, but only because of the age of the warrant and the fact that she has counsel there.
But we don't know that.
Well, but I'm saying if the information for that counsel can be sent to.
I mean, I'm not going to give you a PR bond. This case is 10 years old. You've been I need you to understand that we mean business. I'm not here to play games. And so that's why we have to set it sufficiently high so that you realize that you have to have skin in the game so that we know that you're going to go back. I'll let you guys talk about it. I don't want you to make a decision here in front of everybody. So you guys talk about it. I'm not stuck on the 5,000. I go back down a little bit, but it's not going to be much, but
I'll stand down. Thank you, Judge.
So,
Yeah.
So
Yes, sir.
I'll let you guys go talk.
Okay,
I
sir.
want you to say something here that you might invariably regret because it's in front of everyone, Okay, please.
Thank you, Judge.
Thank you,
I'll
Judge.
go down some, but a reasonable amount.
Let me talk to this.
Trey,
Good morning, Judge.
hi, good morning.
You're on a fugitive case, Mr. Kimball. Mr. Kimball wanted to talk to you about bond.
I'm happy to talk to you. Do you mind? Please. Good morning, Mr. Kimball.
How you doing?
Pretty good. So I've never met you before. I don't know who you are. All I know is that your lawyer is asking me to, I'm assuming, set him a bond, right? You're wanted from somewhere. I don't know for what. I don't know why. I don't know if I'm going to set you bond. I got to get to know you in the short time that I have you here to see, are you a danger to my community? If we give you a bond, are you going to go back? I have no idea. So let's get to know him. Amy?
Judge, so he's wanted from Guadalupe County, New Mexico, aggravated battery against a household member with a deadly weapon. As the court knows, he's also being held in the 351st for credit and debit card abuse.
No, I had no idea. Say it.
And I believe they also just filed a motion to revoke his probation on the fraud use.
He's on probation too.
Yes, and they're motioning to revoke as well. He also has 2 bond forfeitures that I'm seeing, and then he has quite a bit of history with burglaries and.
My gosh. Whoa. So since 2007, possession of marijuana, possession of a controlled substance, evading arrest, possession of a controlled substance, felon in possession of a weapon, attempted evading arrest or detention, tampering or fabricating evidence, evading arrest and previous conviction, burglary of a building, possession of a controlled substance, burglary of a motor vehicle, evading arrest, credit card abuse, burglary of a motor vehicle, evading credit card abuse, possession with intent to deliver, and 1, 2, 3, 4 more burglary of a motor vehicle, failure to ID, possession of a dangerous drug. You're on probation for a fraud. You pick up a new credit card abuse, and you want me to set you a bond?
I understand. Can I please tell you something? If you don't mind me speaking.
Don't talk about the case.
I'm not talking about no case.
Okay.
I was in here, been held on the case for defendant violence in New Mexico, right? And they just got called ATW twice. They did not release me. I was not released. They sent me back to my cell, and since they didn't release me, they ended up putting a credit card abuse on me. Now, I don't know, where that falls in or whatever, they just put it on me.
So if I can give you a brief synopsis of the timeline, Judge?
Sure.
So January 15th, he waived extradition for his New Mexico case, which is why we have the fugitive. He also had a Dallas County hold at the same time, which means the Dallas.
Here's another.
True, but Dallas County had 10 days to pick him up. So they did not pick him up in those 10 days. So let's say January.
I know that. I get it.
Let's just say, okay, so they didn't release the whole, they should have released the whole 25th. They didn't. What they did is instead, 3 days later.
Talking the Dallas County hold.
Dallas County hold. So what should have happened is that on the 25th, they released the Dallas County hold, which at that moment, there was no locals or anything pending, and they should have started the timeline for New Mexico to come pick him up. But instead, Dallas did not release the hold until I believe the 29th, because conveniently, on the 28th, the DA's office filed 2B charges on a credit card abuse from a case that they had had since November. So
December. I see here, December 22nd, 2024.
I'm sorry, from December, you're right. So it just seemed like the timeline expired. And I believe Mr. Kimball's just really upset because if it should have worked like it should have worked, then, why didn't they release the hold in time? Why didn't the DA's office file it? It just seems like they're sort of dragging it along. I understand that he does not have a bond on his felony cases, and they did file the MRP. He has an attorney there who is going to be requesting to set a bond there. What Mr. Kimball is asking is a bond here, even though, and I said, he's going to be making the bond there in felony. So let's say his bonds get set in felony and his bond gets set here. He wants to bond out and go to New Mexico, address that case, and then he said he'll be back and forth. He's already got the MRP and the felony credit abuse case here, but he wants to be able to fight them in the free world, and he is willing to go to New Mexico, turn himself in. I've been in contact with his mother, and I guess just because of that lapse in timeline, it's kind of like why we're here, because, in part, if you have anything else to add, I think he just feels kind of screwed by the system on this. Is there anything else, Mr. Kimball, that I missed?
Nah, did she send the video to your phone? Oh, all right.
In 2023 alone, Mr. Kimball, you have 1, 2, 3, 4, 5, 6. In one of the misdemeanor cases, you have presumably a bond at 5,010, which tells me that you've taken off on that case as well. You're on probation. You had a hold out of Dallas for, what did he have a hold out of Dallas for?
Violation.
Dallas?
You're hopscotching with the states with the criminality,
No,
man.
I
I
got
can't.
look, I had all the cases together and they gave me probation in Houston and Dallas. See, that's what you don't know. They dismissed a bunch of them cases has been dismissed. And I've been to trial twice. A bunch of them cases has been expunged on that record right there that you're saying. You know what I'm saying? But they gave me probation in Dallas and Houston. Dallas supposed to transfer my probation to Houston. They did not transfer my probation to Houston. That's how I get a violation in Dallas. I never violated by kissing any new case. The only time I caught a case is when for the New Mexico, say something happened in a family violence 2024. I'd never even been to New Mexico. The girl wrote a statement on me saying that I violated whatever. I understand. I know I don't supposed to tell you nothing, but I got videos. She's saying everything that she said is a lie. I don't even supposed to be having a case for new. I wouldn't even supposed to come to jail for that case. She has the videos in her phone. She can show you. She's showing her ID, everything, making a whole statement saying that everything that she said to me in New Mexico is a lie, bro. I'm just dry getting hold for this case.
We really,
I understand it.
it doesn't matter.
Yes, sir. I understand it.
It seems to me,
Yes, sir.
you get out, you pick up a new case. You were out, you just picked up a new credit card abuse 2 weeks ago. December 22nd, I mean, maybe 3 weeks ago, you just picked up another case. You're on probation in Houston. You're on probation in Dallas.
Yes, sir.
You got an open case in New Mexico.
Yes, sir.
I can't possibly give you a bond, Mr. Kimball. You know, I think that I need to protect my community. And if I give you a bond, I'm scared that something else is going to happen. I don't want you to pick up a 6th or 7th case, you know?
I ain't pick up a case. I came to jail for a case a year ago for New Mexico. I was already on probation.
Picked up.
No, they just put
credit
a
card
case on me while I was in custody. I didn't never get caught for anything. They just put a case on me while I've been in custody right now. This time, waiting on New Mexico and Dallas to come get me. They just put this case on me. They just put this on me.
I want to make sure that there are no more new cases get on you anymore. I'm not going to give you a bond because, Mr. Kimball, you scare me. You know, you do.
I never had an aggravated case. I never had an aggravated case in my life. You see my record. I never had an aggravated case.
I don't see, the only thing I see is Harris.
Everything you're saying. I never had an aggravated case out of Harris County, Dallas, anywhere in Texas, ever. Ever.
I believe you, but it's just way too much baggage, dude. Way too much.
But I'm saying you can't just set a bond on the case. And when I go to court, you know what I'm saying? I talk to my other judge. She give me a bond on them cases or whatever, where I can go handle everything that I need to handle so I can get out and be with my kids. You know what I'm saying? Because if I don't, so say if they do set the bond when I go to court, because he's going to give me a court date in like a week or two. I'm going to go to court. They're going to set a bond for me. So they set a bond. Now I got to come back to your courtroom again for you to say, oh, well, I'm not going to give you a bond or whatever. They got 14 days to come get me. When actually I really supposed to already been gone to either Dallas or New Mexico because they called me ATW twice and they said they was not going to come get me. And we called to New Mexico. New Mexico said they didn't have any knowledge of me even being in jail on their warrant.
Is New Mexico, have they stated that they're going to come get him?
Our indication at this time is that they want him, Judge.
Okay, they're going to come get you. You know, the problem is that 14 days is told because you've not made bond on those cases upstairs. Once you do make bond at that point, that will get the 14 days for New Mexico to come get you. But Mr. Kimball, you've got a ton of priors. You're on probation in two different counties. You got okay, regardless, it's too much baggage. I'm not going to give you a bond. You scare me, dude. That's it. Really. You know, sometimes the bill comes due. Now is that time. It's not going to happen anymore. Okay, thanks. Hey, ready? Hi.
This one here, let's see.
Why does this continue to happen? The peeling.
Segment has adverse effects on my body. Yeah, if I'm stepping down now, it's gonna be on
How many times have you switched medications?
the medication since I was 12.
No. Now, how many times have you switched your medications? You're telling me it's an adverse effect of the medication that you're peeling your face.
Oh, peeling my face? No, that's I said sorry. It's Rocky Mountain spotted fever.
It's what?
Rocky Mountain spotted fever.
So, Your Honor, he's diagnosed with schizophrenia. Of all defendants, there are active symptoms of use disorders. There's a delusion that he has some kind of parasites under his skin. We've hospitalized him with an NPC. That NPC uses medication. They do prescribe medication, comes back, uses to take the medication, continues to scratch, gets blood all over the place. Other clients are complaining.
using a program continually tells me I don't want to be in the program, nothing wrong with me, I don't feel anything about it.
They consider it a delusion. This is an actual medical condition, like about spotted fever, and they want to call it a delusion. But
If you take the medication, things will start going well.
This for mental conditions, for the schizophrenia, that has nothing to do with the actual medical condition. Is it, I mean, they're denying any medical, anything medical to do with this. They want to make it out like it's all mental.
Mr. Akers.
It was the problem I was having when I come in here and you're standing up there, you wouldn't let me speak, and you say you're rotting.
I'm trying to prevent you from killing yourself. You're doing it slowly. And I've seen the deterioration that has happened in the last 2 years that you've been with me. And it's not going well. All they're trying to do is help you. And by taking the medication, that's what's going to happen. When you don't, that's when everything starts happening again.
That has nothing to do with the medical part of it. I've been on social disability since 2002.
Okay. How do we get you to take the medication?
I would take it. Lost two. I left my ex-wife. I left Missouri. I lost 200 pounds, and I've lived my best life since I've been off the medication. I told the lawyer before I went there. I said I'll do fine if they don't try to force me to take medication. I went there. The psychologist said, I'll give you a sleeping pill, melatonin, PRN. That's all he gave me. And the nurses, they bulldogged me until they kept bringing me back in front of the psychologist, making stuff up until they were prescribing me. They sent me to the hospital twice. I come back from the hospital with no medication. I got back. The nurses bulldogged.
He's on probation right now, right? If you are not in compliance with your probation, then it's very possible a motion to revoke gets filed.
That's fine with me. I'd rather just do my time.
So let's do this. Take a seat for me. I'm going to appoint your lawyer. I need to appoint a lawyer. I don't know yet. There is an adage, a saying that goes, you can lead a horse to water, but you can't force him to drink. This is exactly what's going on here. I've been trying to get you help and you just refuse to take it. But what's going on now and what they're alleging, how you're, I guess, are you saying he's peeling his face and putting blood on places? That's just unacceptable. And all we want to do is prevent you from killing yourself. When you come in here with new cases, I see the way you are, and it's not good. And I mean, who am I to try to help you if you don't want to help yourself? So if you want me to cut you loose today, I'm going to do it. But you can only treat your body this way for so long before your body just explodes on itself. It's just a matter of time. I don't want you to say anything. I want you to think, because the idea is that you get help in whichever way that you can, because the way that you're treating your body, it's going to come back on you. You can't live like this forever. You get older and your body worsens with age. It doesn't get better. When you get out there and you're out there in the free world, think before you act. Think before you speak, because every time you come here with a new case, it's not going to go well. If you ever want help, all you have to do is come back and I will get you whatever you need. If you want a cell phone, if you want a tablet, if you need medication, for whatever you may need. But living the way that you are, you start using dope on top of it, your meth or whatever it may be, all you're doing is making things so much worse. If you don't want the help, I'll just cut you loose today. Just tell me what you want. You're old enough to make your own decisions, and I will do whatever you want. But if you don't want it, I'm not going to force it on you.
I'd like to go. The horse, you lead it to water, but you can't make it drink. It comes from running a horse so hard that once you get it to water, it's too tired to drink water to save its life. I understand what you're saying.
It's always a way, Mr. Akers.
The lesson learned.
Actions speak louder than words. So we will see. I'll cut you loose today if you want it, but you come back, it's really not going to go well. Do you understand?
Understood.
Okay. So you let me know whatever you guys want to do. If he wants to unset term, I'll do it today. And then, yeah. So I'll let you speak with counsel. You let me know what you want to do.
Thank you, Judge. How do you feel?
Yes, ma'am. You want to talk to me real quick?
Yes. Well, it's not gonna be quick, so.
It's okay.
Okay, so I'm here
I
on,
need it ever quick. Anyway.
I'm here on Miss Gill. She's set, for a bond today, and
She in
so
custody?
she is, yes, Your Honor. And she has one pending felony, but she's out on a bond for that one already. She just has no bond set in this case.
I see bond sets. I see the FSGI is at 1,000. Yeah.
Okay.
It must have just gotten set. I don't know.
Okay, is it a PR bond?
No. It's a
Okay.
show.
Okay, then if we could review it today, is that possible?
Absolutely. Do
Okay.
you mind, Deputy Etchigon, do you need a translator?
No.
Do you mind me bringing up Ms. Gill? Maria.
Felony a PR bond then?
No. Initials for the kid.
Okay.
All right. Good morning, Ms. Gill.
Good morning, Your Honor.
I wanted to bring you out because we're talking about you, and it's only fair that you get to hear what's transpiring since these are your cases.
Yes, sir.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Or, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay. Good.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Road in Harris County, Texas, regarding an FSGI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallaceville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The
So are you
complainant,
telling me that now it was intentional?
the complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck her vehicle. The estimated damage from the complainant was around $4,000, and the defendant stated she didn't stop because she was hungry and colored.
And what?
Colored.
Color.
Yes, Your Honor.
Can you look up to see if she has a valid Texas driver license?
Yes.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege to drive You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt, I can have a contempt hearing. I can have a contempt.
After.
Finish.
I'm so
please.
sorry.
Finish.
I'm a commercial driver.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
In this case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally. Because allegedly hungry and covered. So now this is an affidavit, and I hope that you take it seriously, because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor. May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. She has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she is willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what, Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, I mean, really,
don't say anything.
how many people died this weekend on the road because of the reckless and wanton actions, you know? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping me. I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this. Okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children. My children have trauma, okay? And I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point, your actions become your own, right?
You don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
I call out discrimination when I see it on a daily basis, ma'am. I don't care who it is. I don't care what color. If they're a small farm animal, I don't care. I call it when I see it. The only thing, because I don't know them. The way I get to know them is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes, really?
Officer Harris did not read me my rights.
Well, I will let
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
Yes.
She just brought me to jail.
You guys speak about that. I'll tell you, look, here's what I'm gonna do. I'm gonna leave your bond at $1,000 now. All right, I'm not gonna raise it to 5, but I can't continue to give you a PR bond.
From employment too.
Listen,
Okay.
do not drive. It's the only thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new
Yes,
case
sir. Yes, sir.
and just, all right. Come on. Justin. I didn't want you to leave because I know you've been waiting.
Oh, no.
I don't see a Herrera.
Herrera.
Oh, sorry.
Bottom of.
You are Carlos Barrera. Sir, you're charged with terroristic threat. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On September 11th, 2024, in Harris County, Texas, an officer met with the complainant who advised that in the morning he received multiple phone calls from an unknown number beginning at 4:30 a.m., lasting through 4:50 a.m., in which the defendant called a total of 5 times. The complainant stated he did not answer the phone from previous knowledge that it was the defendant calling him to confront him. The complainant stated he left to work, and when he returned at approximately 4 p.m., he noticed multiple phone calls from an app-generated phone number that called him a total of 18 times. The complainant stated that on the 18th call, he answered the phone and let the defendant talk. The complainant was able to get a second cell phone and record the defendant stating, "I know where you stay at, you don't know where I am." The complainant stated he had sent a text message to the phone number that the defendant kept calling from, and said that he did not wish to have any contact with him and to leave the complainant alone and stop calling. The complainant stated that during the conversation over the phone with the defendant, before he was able to record the phone call, the defendant stated he was going to shoot the complainant in the legs so he could not work as an electrician. The complainant stated that the defendant is the complainant's current girlfriend's ex-boyfriend. The complainant told the officer that he believes the defendant is capable of carrying out his threat and the complainant is in fear for his life.
Got it. All right, Mr. Barrera, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have contact with this person. Do you understand? I'm also ordering you not to be in possession of any weapons. If I find that you violate any of these conditions, if you are a danger to my community, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand?
And Judge, given my conversation with the complainant that I had yesterday, the state would request a GPS monitor because he has continually gone to the residence since this incident and has made threatening comments towards the mother-in-law as well. And recently, as of a couple of days ago, I guess he left his wheelchair outside the home in order to make some sort of threat that he's been going near the residence.
So the threats are still continuing?
Yes.
Sir, I'm now putting a monitor on your ankle so I know that you're not going over there. You're not to go within 1,000 feet of where they live or where they work. Do you understand? Hold on. I don't want you to say anything. I will give you a lawyer today. You can talk to the lawyer, but understand my only concern is community safety. That's all I care about in this life. You know, we take things step by step. Let me do this. I'm going to give you a lawyer. I'll let you talk to the lawyer. I got a bunch of DAs here. Whatever you say, they're going to use it against you. Let me give you a lawyer. We'll go from there. But don't go where they live. Don't go where they work. Don't accidentally bump into them. Do you understand? So for now, I am going to put a GPS monitor so we would know where you are. And you're not to go anywhere where they live or work. I'm going to have you now sign a receipt of Victoria. After that, we'll just have you wait for the lawyer that we get and we'll go from there. Do not leave until you sign our bond conditions. Otherwise, I'm going to revoke your bond. Okay? Felicia, it'll be with you because you're monitoring. And waive the fee. The deal is this, is that life is way too short. Life is way too short to make a decision where you make it, or you've dug yourself a hole so deep that you'll never get out of. There are plenty of other fish in the sea, and it's time at times to just move on. Cut your losses, move on, because life's just way too short, you know? There are other people out there, and as long as I know that we don't have any more issues in the future, I'm willing to take it off. But at this point, I got to know that it's going to stop, right? I'm not going to take your word for it that it's just going to stop. I need more than that. So that's why I put this monitor on you. After some time, if I know that I can trust you, then perhaps we can amend the conditions to take it off. But at this point, all I have is that you've picked up a criminal case. They're alleging that it's continuing to happen, and I want it to stop. Not I want it. It's going to stop one way or the other. I told you, life is too short. Move on. That's all that needs to happen. Do you understand?
But you know that I got shot.
Okay. So you've got a lawyer, right? My only concern is that you don't have any contact with these people and you don't go where they work. The past, I get it, it's the past. I get that you guys have bad blood. All I want to do is I want to prevent further bloodshed. I don't want any more bad blood. That's all I'm asking. I'm not asking for something unreasonable. But what we can do after some time, I'll have them reach out, and if there are no issues, I can take it off. Do you understand? All right. I'm not asking for much. Just move on. You know, it's just like I said, people here in life, in the jail, are there because they have no self-control. They just wig out. They do stuff without thinking, and then they make some kind of decision where they're looking at 40 to 50 years. Don't. It's not worth it, you know? Okay. All right. So after some time, come back. Good. We'll take it off. Okay.
Yeah, I can.
Good morning.
Good morning.
How's jail?
It sucks.
Great. It's supposed to. Not supposed to be fun.
Yeah.
Problem is every time we give you a bond, you have like little wings. You take flight.
I don't take flight. It's just, okay, so.
Okay.
to
You don't, technically, you don't show up.
To be real with you, my transmission on my car literally did break down last time. And this time I made sure everything.
Take a bus. Phone a friend.
Well, where I live, it didn't have a bus route. But I do have Uber already scheduled. So there's no chance that I'm missing bond. Like, there's no reason why I would even miss anything.
Shame on, fool me once, shame on you. Fool me twice, shame on me. Fool me thrice, what is it? You've taken off on me 3 different times and you want me to give you a 4th bond? Really?
I want to prove myself to you.
Mm-hmm.
Literally. Like, I have what it takes.
And Judge, I'll say, I have her information. I have information of her boyfriend and some other people. And my office will hound her, will call her and make sure that she's
I'm
there.
all about giving people multiple chances, but I've already given you 3. At some point, I have to say when, because if I don't, then I've done it 3 times. You and I've had this conversation before. The last time I let you out, we had the same conversation we're having now.
Yeah, I know, but literally, I'm done, like, this is it, like, I don't want to see myself back here, Judge, like, I don't want to do this anymore, I don't. Like, I want to prove to you, I want to prove to my family and myself, this is it, like, I don't want to do this anymore, I have a kid, I have a job, I'm fully time employed, like, I don't want to do this anymore, like, this is it for myself. And I'm speaking 100% just you and me.
I don't believe you've sold me this. You've sold me the snake oil before, you know?
I've never actually got.
Sean, what I would like to do, and I agree with you that you can't keep doing what you're doing, especially if you have kids, because, you know, if you're a mother,
I am. I just want to come home.
that child needs you,
I know.
you know? Hey, where's mom? She's in jail.
I
You
don't
know?
want that to be response.
So what I would like to do, because this case has been open for a long time, perhaps do a TRAS. Let's see what they say, and we'll go from there. But so I have clinicians on staff. They can tell me exactly how we need to head. They will interview you, see what's going on in your life, to find which fork in the road to take, how to take it. They may say, okay, let's get her to do outpatient treatment. They may say, let's get her to do inpatient treatment. They may say she needs no treatment.
I don't want to do that. Can I take the conviction? And I know what I'm looking at. I understand what I'm looking at.
I don't want to say
understand
that.
what I'm looking at.
You need to talk with Sean about that.
So,
Okay, I have.
Your Honor,
I have.
just my concern. Look, I don't want to render an involuntary plea or anything like that as a result of her wanting to get out. Our conversation back there was for a decent amount of time, and I have no problem, like absolutely hounding her to make sure it happens so that she can be here. And if she's not, that can be on me.
Sean, that's the 4th time. I'm not going to do it.
So if
I've done
it's,
it. We had the same conversation the last time we were here.
So if it's not in the arena of PR bond or anything like that,
Okay.
can there be a number assigned, a set bail amount that she want
Can I-
to make?
Can I do?
If in the event that she could.
I
Can I do
will
this?
give you a bail reduction, of course. I will do something reasonable just hold on.
Okay, but I can't make bond. I know for sure I cannot make bond right now. I know if I do the conviction, I know what I'm looking at next time, and it's a state jail felony, and I'm willing to take that. I'm willing to take all of that. I'm willing to take all of that. I need to get home to my kid. Please, Judge. Please. I know what I'm looking at. I know what I'm looking at.
I would think.
I'm comfortable with it. I'm comfortable with that theft charge on there. I know what it looks bad. I do. But I'm willing to take that right now to get home to my family.
Whatever you guys want.
Okay.
So I mean, if you think this was tough, wait till you get upstairs in felony court. It gets so much worse.
No, there's not gonna be another.
If I had one strand of hair every time someone told me that,
And I get that.
I would look like Alex.
He has hair.
That's my point.
I don't get
Every
it.
time someone told me that excuse, if I had one strand of hair, I would look like Michael. Well, not like whatever you guys want to do, you know me. I can't, look, hey, I can't keep doing it. I have to show you that we mean business.
And I know I do, but let me show you that I mean business as well.
Okay, so let's do this. Let's do a deferred where it stays off your record.
I want it on my record though. I want that on my record and I want to take that on. I do. I really do. No, I do. I do. I do.
So how about this, Judge? Me and her will talk.
But I would, just hear me out. Look, I don't want to keep you on paper forever. But if we were to do the TRAS and you do treatment,
I'd rather.
as soon as you're done with the treatment,
I'd rather
we'll successfully terminate.
I'd rather take the sex. I'd rather take the sex conviction. In all honesty, I'm comfortable with that. I know what I'm looking at.
Don't want to clean up?
I want the sex conviction. I do. I want to take that. I want to
Guys
take that
talking,
on.
let me know what you want to do, Sean.
So just for the record, so at this time, personal bond or reinstatement is off the table. And then if a bond amount is set, what would
The
that
bond
bond
set of 7503. So if you want something different, I'm happy to give it to you. Whatever, something reasonable, whatever it may be, You have the conversation. If you want to, you just got the appointment today, right?
Yes.
If you want to roll it to Monday for you to do your diligence, that's also a possibility. Whatever you guys want to do, you let me know.
Get it worked out.
Okay, thanks, Sean. All right. Yeah. Michael.
Good morning, Your Honor. I'd kill for a head of hair like yours.
Like mine. It's fine. All right, I got you.
Just about to just, I spoke with Ms. Hawkins, she's downstairs.
Okay, thanks.
Hey, thank you, Your Honor.
Ready? Hey. Is it Gaston or
Gaston?
Gaston? Mr. Gaston, you're charged with 2 cases. You're charged with evading arrest or detention and unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 14th, 2025, an officer observed a vehicle speeding on Gulf Freeway feeder by radar device going 72 miles per hour in a 40-mile-per-hour zone. The officer then observed the vehicle turn left at a red light. A traffic stop was initiated. The officer instructed the driver to step out of the vehicle, and the officer began to detain the driver. As the officer was detaining the driver, the front passenger, the defendant, exited the vehicle. The officer instructed the defendant to return to the vehicle, and the defendant ignored the officer's instructions and started to walk away. The officer ordered the defendant to stop, and the defendant started running northbound. The officer observed the defendant place his left hand near the front of his waistband and throw a small black and blue object near a fence. The officer informed other officers of the defendant's location. Officers observed the defendant running eastbound on the 3,300th block of Scott Street and attempted to apprehend the defendant. The defendant was apprehended at the 3,100th block of Milby Street, approximately 0.2 miles away from the scene. The officers searched the area and located a firearm. The officer remained in visual contact with the location and no individuals approached that area.
What are they doing wrong? The officer just stops them and just arrests them? What for?
I'm not sure why the officer immediately detained him.
Really? Is that what we do now? We just stop and arrest? No, I'm gonna find no probable cause in your case. Just be careful, man. If you got a gun, God forbid you use it, something happens, you dig yourself in a hole. Come on, man. We got one life. Be smart. Go to school, get some knowledge, make a ton of money, Take a seat, please. Thanks, bud.
What's the last name, Judge?
Gaston.
Okay.
On both, no PC.
All right, Judge, next is page 6.
Did they arrest the driver? Did they charge him with anything? Do you know? Do we have him for anything?
No, there's no connected cases.
Just driving while black.
Your Honor, I would just, I'm gonna point something out here. It was a speeding stop where the passenger was getting out of the car. I would say the officer would have the right to at least make sure the passenger was in the car while he was conducting a stop. That's his.
Yes.
I don't even think that's an arrestable offense. It's not an arrestable offense. They just literally pull him out, he's speeding and they arrest him. And then the co-defendant's doing nothing wrong. He just gets out of the car. He can just walk away. Yeah, I don't see anything wrong.
Thanks, appreciate you. Of course.
Good morning, Mr. Mazzell.
Good morning.
Your lawyer's asking for me to set you a bond. You
Yes, sir.
now stand charged with, I guess you said home improvement fraud.
Judge, essentially, that's what it sounds like the allegation is. It's a failure to possess the required license for home improvement.
I have your fraud.
This was in 2020, during the 3 hurricanes that hit Louisiana. And according to City Hall, and we went down to everybody and they said we didn't need one because it was an emergency situation. Everything was flooded and devastated and we were just trying to help out.
My only issue is that this is now a second fugitive case that you have.
The first one was a lady that we did work for.
Let's be careful.
Doesn't matter.
Oh, sorry.
Miss Mr. Mazzell is that, we usually, as a matter of courtesy, I guess, so to speak, we'll give you a chance when you get one fugitive case. But we can't continue to do the same thing over and over and over.
Understood. Understood.
Amy, do you know anything about this?
Yes, so first I'll state it as opposed to a bond. This particular case is because he didn't have a license, but it originated out of the fact that the complaining witness, after a hurricane, had paid the defendant money to repair her house. He did not do so. The money amount was.
So he allegedly took money for fixing the house and didn't do the work.
Correct. And then when the officers went to go look him up, he didn't have a license under that name. So that's the basis the basis for that charge. We are, of course, opposed to a bond given that he has had a prior fugitive case. He was granted a bond on that one, but he didn't actually show up. Looking back at our notes. The only reason
we gave him a bond, he bonded out and he didn't show up?
No, he appeared, yes, he appeared in court on that day when you guys provided him a bond. He appeared in our court here in Harris County.
Okay.
The only reason that case was dismissed is because I believe that the main jurisdiction in that case had recalled their warrant or something of that nature.
So he didn't turn himself in?
No.
The lady that was charging us, I ended up paying her $21,000. And she dropped the case.
How? I suppose, we can't just take everybody's word for what they
But
said.
first off, I did not know that even the warrant existed. So I had no idea. But I ended up paying the lady off. I gave her some money and said, okay, that's good, we're fine. I truly didn't think we did a very good job.
Okay.
But may I ask you this? This is an LLC. I have a business, or had a business partner at the time. We were 50-50 in the business. I just wonder why I'm the only one being charged here. I mean,
Facts beyond what I would know anyways. The simple thing about it is that I gave you a bond last time. You bonded out.
Yeah.
You didn't show up. And now you have another fugitive case. We can't
I
continue.
bonded out and I paid the lady off and she dropped the charges.
That case was dismissed? Is that
Yeah, the
correct?
case was dismissed.
Not because he showed up like he was supposed to.
I see what you're saying,
He
Judge.
came to court on the day that he was due to go turn himself in Louisiana. I don't know, but I can't continue to do the same thing. The good news for you, Mr. Mazzell, is that it's Louisiana. So we have buses coming from Louisiana probably 2 times a week. So from the time that you waive, within the next probably 2 to 3 days, you'll be back in Louisiana to be able to answer the charge. But I'm not going to just continue to give bonds on fugitive cases when you continue to pick them up. Because.
Got it?
Okay. Has he waived or did he refuse?
To refuse extradition.
Okay, so you need to decide what you would like to do. If you want to waive extradition, I would say probably within the next, 3 days, Louisiana will be here to come get you. If you want to refuse, which is well within your right, the state can get a governor's warrant, but that'll take 90 days. And at that time, they can have you remanded
I
back.
can sit in jail for 90 days. No, I'm not interested in that.
So, but I'll let you talk to James to figure out what you guys want to do, and then you just let me know.
Okay.
Hi, Judge. Same old, we're here on Miss Gillis.
Thought I had it open. I closed it. All right. So Judge, she's one out of Pennsylvania for theft by deception, false impression.
False impression.
So this one will be asking for no bond on the extradition because over the course of 6 times, she stole $780,000 from an elderly, and it shows from the hit that she's an international flight risk with a non-American passport.
That's the first time I've heard that, an international flight.
That's what it
flight
shows
risk.
on the
Is
hit.
Interpol involved?
Well, so that's why I was surprised because this was a DHS referral. I was kind of surprised there wasn't a nice hit because she's not a citizen and it shows. So I don't know.
The bond?
Check.
I want a PR bond.
PR bond. Okay, so let's bring her out, please. Gillis, if you don't mind. Yeah. Joe, you want to talk to me while we wait? Ms. Gillis.
Yes.
Good morning. So your lawyer is asking for me to set you a bond. I don't know. I've never met you before, and I have about 5 minutes to get to know who you are, to see whether it would be right to set you a bond. I have no idea what you're charged with, but the problem is that you are an inherent flight risk because you're wanted out of another jurisdiction. There's a warrant in some other state, and we got you here. Michigan.
Your Honor, around October 31st, 2023, it's alleged out of Pennsylvania that this now defendant manipulated a bank to over 6 transactions, caused a total loss of $780,000 to an elderly individual from the retirement fund. There has been regarding the affidavit, when speaking with the complainant, states that the checks for the individual were mailed out to her name with the corresponding physical address. On notification from DHS, it shows that she is an international flight risk, and due to those factors, the state would be opposed to a bond for the extradition.
Why would the Department of Homeland Security say that she's an international flight risk?
I'm not sure. I can reach out to them, but obviously if I reach out to them, I can reach out to DHS and ask why. I only get the notification, and so I haven't spoken with an individual. But
what other criminal history does she have?
She does not have any others, just the 6 incidents arising from this affidavit.
I can clarify.
Please.
Possible. I believe they think she's an inherent flight risk because they arrested her at an airport on a connecting flight, which sounds terrible, doesn't it? I'm thinking, oh, she's leaving the country.
Really? Was she headed out of the country?
No, really. She was going to Jamaica. She's from Jamaica. She comes back and forth for business. She's got an H1,
H2B,
something about H visa. And her father is a US citizen. Here's the kicker, Judge. She gave birth January 30th of 2025.
Okay.
She's breastfeeding. So when our lovely county got her, they said, too bad, so sad. She's been in custody for 4 days. They've refused to give her access to a pump. She has asked for a heating pad to do it herself. They've only given it to her 2 times.
I mean, we'll see about. I'll reach
I
out
just
to
think
medical.
this is
Don't worry about that. I'll reach out to medical.
That
and
is
see what-
insane.
Yeah, I know
But,
it sucks.
like,
And
6
that can
days
happen.
later, and I'm like, she was clearly arrested with her child, okay? So it's not like she's lying. But I just think because of that, let's add some other things, because that by itself is like, oh, that sucks for you, right? But it's a 2B. It's not like she's a flight risk. It's not like she's a failure to appear. I get that it's like a theft by deception because of some bank mailing thing. She's never given an opportunity to go turn herself in. So I think that considering the fact she's never had an opportunity to turn herself in, this is not where she's just like running the country. She comes here back and forth. Her child is born here. Her father lives here. Connected with the fact that she has some problems going on with her 1-month-old that she's going to have to figure out. I'm asking for a PR bond. I'm asking to give her a chance. We've already done her wrong.
Before I give her a PR bond, I would like you to figure out why they're saying that.
For the international flight risk?
Yeah.
I'm more than willing to.
Not only that, but you're telling me that she does this all the time? Let me see.
Do you go back and forth? You can tell the judge yourself.
I have a travel visa. I have a visiting visa for the US, which is a 10-year visa, and also have a H2 visa, which is a work visa. I worked in Utah, I worked in South Dakota, South Carolina, Massachusetts, Florida for the past 5 to 6 years, back and forth. And I also do extensions.
Prove all this.
Yes, I do. The currency office do have my passport with my visa currently stamped in it.
So let's do this. Let's roll it to tomorrow, because I don't think wow, is it already 11:30?
Yes.
Holy moly.
So they do have it downstairs in the old.
Tomorrow, I want proof that she does all this international travel routinely, so we know that she's not just trying to take off.
No, sir.
And then I'd like you to reach out to them to see why is she an international flight risk. Is it a 2B?
It is.
You know, I'd like to know how they justify saying that, right? Or do you just think because she's on a flight now? I don't know. That's why.
I'm perfectly willing to call. I'm just obviously aware making the call to DHS regarding the pending Pennsylvania charge. Yeah, I've always got the trigger, so. Because she doesn't have an accent right now, but because she's on a visa in terms of what they decided about.
This is crazy.
So like I said, I'm willing
Because
to.
then ICE is going to put a hold on her.
That's what I mean. It's like
ICE is going to do it regardless.
ICE has not put a hold.
No. If she's here with the proper documentation, they're not going to put a hit on her. If she's here with the visas, then there's no reason for her to put a hit.
Judge, they're deporting students nowadays, but hey, that's okay. All right, I'd like to put you on the email with medical about the breast pump. I find that outrageous.
Yes, I will help you with that. Don't worry. But I'm not prepared to set her a bond yet when with
Okay,
Mr. Kim saying the international, and then she's on a flight to Jamaica.
we'll get the proof. I'm gonna have to zoom in tomorrow though, but I'll get it handled.
Sure, of course.
Yes, Judge.
Judge, we're here on Jodicia Gillis. Last time we talked 2 days ago, you asked me for proof of her travel back and forth. That's her I-94. So when it says ARR, it means arrived in and departed from. So you can see, yes, she departs, arrives, departs. She's back and forth for years. Just a snippet. She works on H-2B visas for about 6 months to 2 years, depending on her contract, through various companies. Stein Erickson Collection, it's a hospitality, was in 2020. South Carolina Kiowa Resort was 2022 to 2023. And then the most recent one, April to October of 2024, was St. Joe's Company Hospitality, where she works at various resorts. After that, she was here on a vacation visa, so she was not here illegally. And then she has to go back to Jamaica, get her new contract, and come back. So
Have you seen this, Mr. Kim?
I haven't, but I verified through DHS. So it wasn't a misrepresentation, but she was previously on a work visa. However, it expired last year. So legally speaking, she's on a tourist visa. And Shreya's tried her hardest, but she's armed with allegedly $780,000. She's not an American national. She's out here on a tourist
So what we
visa.
would do is we would have her surrender a passport then.
yes, let's do it.
So I mean, that's what it says. Like if Judge rules out, it's going to be the first thing, but just because with the amount of money, just allegedly the amount of money that she has stolen and the fact that she's here on a tourist visa, I'm still opposed at no bond. But if the court grants a bond, that would be my request for.
I mean, I'm okay, we have no other criminal history, right?
No, Judge, but
It doesn't appear that she's a danger, right? She's got a young kid. Did the nursing thing work out?
No, but almost, because of red tape. So I bought it with my own money, but because of red tape, they won't let me bring it. Don't worry, I just verified from Sylvia that at some point, we came upon the conclusion that if you deny the PR bond and if whatever, we're gonna bring her to court every day so she can pump. Then in the afternoons, she has to go to the hospital every day.
I don't know I'm not gonna do a PR bond. Because I think that at the very minimum, you need to have some skin in the game so that
Okay, what kind of bond were you thinking?
I don't know, what,
I said, I still stand by, I have to defer the court because I'm still standing on the no bond because of the circumstances. And so I don't want to beat a dead horse, but just in terms of the allegations and over the long period of time. And again, for the other same reasons is that
I mean, she's alleged to have, close to $750,000.
So how much?
That's,
She's not convicted. This is the question I asked today. She's not convicted, she's charged. And we're not talking about the underlying facts. It was a 2B, there could be various defenses. All we're talking about is how to get her to Pennsylvania. But if we are considering the underlying facts, I would like to know how much Harris County, the sheriff's office, and this court values a mother's right to breastfeed. 770,000? If we're talking numbers, because she has been denied access. The Harris County Jail has admitted and is scrambling. And I'm talking CEO of Harris Health right now. They are scrambling. They have been asking me multiple times, why is she not getting a PR bond? Why is she not getting a PR bond? So I'm asking you that on behalf of the people that I've spoken with, why she is not getting a PR bond, knowing that they cannot provide those facilities. And we're at the point where I have to bring her daily. I'm appointed and I paid for it with my own money. I'll donate a $300 pump, but they won't take it. So because of the red tape, she is.
bring her here so can she use a pump here?
So I
You
bought.
guys okay with that?
And that's the thing. They said, we don't know if they'll allow that because technically she can't go back to the holdover with the pump I bring. So that's asking me to every day bring a pump so she can pump. I'll go home, I'll disinfect it and I'll bring it back. But this is insanity, Judge. She's a nonviolent offender. We don't even know if Pennsylvania wants to pick her up. We're fighting, the state is fighting a battle and saying this woman cannot breastfeed. They barely are getting a pump. And I find this absolutely crazy. She's been in custody for 6 days. She has to go to the shower and hand express. They refused to give her,
Look, she's charged with a criminal offense of.
I'm saying she's going back. She's going back.
$750,000. It just so happens that it happens at the time when she gives birth. I mean, it never, when someone gets arrested, it's never at the best time. Oh, you know what? Thank God I got arrested now. I mean, shista happens, right?
Sure.
It just does. But there's consequences to behavior.
And let's take her passport and make her go back. I have contact with her father who's going to come get her. I've contact with her mother. She's not leaving the country. There's no flight risk.
So for what it's worth, in terms of if she waived, I asked Amy to call to see if it flipped to waiver, because technically and legally, right now, they're only pursuing a governor's warrant because she's a refusal. So I asked Amy to call to figure out when the fastest they could come if she waived today. And she got a hold of Corporal. They're supposed to call her back today because the person in charge of it.
No, that Pennsylvania still.
That's the other question I asked, because technically the decision would lie with the prosecutor. So she's right now calling the DA's office in Pennsylvania, because the sheriff's office only obviously facilitates whatever that decision is. As far as what the extradition confirmation was, they are willing to extra.
I mean, look, at the end of the day, I can't show preference to anybody. I get it that she's nursing and stuff, but how am I supposed to show preference to anybody? I have to be fair to everybody. I can't show preference.
It's a nonviolent first-time offender.
Well, so that's why
Flight risk.
I'm not asking you for $25,000, because otherwise in this type of situation, I would say no bond or somewhere in the neighborhood of like 25 grand. So I don't know.
I'm sorry.
Like $1,000?
I don't.
Fine.
1,000?
Sure.
Okay.
There's consequence. Can you bring her out, please? Guys, do you mind bringing her out? Gillis?
And sorry, and this obviously is relevant, were you able to confirm who actually has her passport to surrender? Because if that's going to be a condition of,
The DHS wherever she got arrested.
okay,
Oh, I'll ask her right now. She knows.
okay. Because I'll have to
So
call, because I'll
what's the
concern.
actual charge? Is it like misappropriating?
So the way it was written was theft by deception, false impression. But then I'll have to because the alternative is if it's going to be kept in DHS, then it would be an order from the court that would be submitted to DHS so that they don't inadvertently release it to another authorized party. Because otherwise it would have to be surrendered to the clerk's office, which obviously to facilitate that, that's going to take a couple days. Because they have to bring it here and release. I don't know what kind of form they have to fill out.
So I'm going to give this back to you. Do you want to see this? So it looks like she
Well, I
does.
accept on the
She
travel.
does travel credit.
Did I forward it to you? There's so many emails.
I don't take
Um,
issues on
Here,
the
you want
travel
it?
part.
Let's, come on, Amy, say they don't want her.
I went to call, they didn't answer. I think they're on lunch break because they closed during the lunch hour system.
Seriously?
Yeah, I did leave a voice message with the person I talked to.
I will call after the approach.
Well, regardless though,
Well, no, I'm saying if they don't want to extradite, then the bond becomes irrelevant.
Then we don't have to fight.
I'll call, I'll figure it out. I'll get it to somebody.
I mean, I can't imagine that's why, really.
It's Pennsylvania.
I don't know.
Who has your passport right now?
It's in Orden,
What do you mean holding? Like which?
here downstairs.
Oh, they have it here.
So then they would have to be surrendered to the clerk's office.
Yes.
Yeah.
Okay, so it's at the,
Yes, evidence.
got it, okay.
Okay.
So that's even
And
better.
I think Paria has a copy of the form if you don't already have one to
Okay,
have.
I'll email it.
So your lawyer is asking for me to set you a bond so that you can go turn yourself in to Pennsylvania. I will acquiesce and I will set your bond at $1,000. However, before I do that, I'm ordering you to surrender your passport because I'm not going to trust you that you're not going to go. You do a lot of international flight and I don't want you to take off on me because I need you to answer the charges that you're wanted for out of Pennsylvania because that's what we do. So the other thing I need you to understand is that from the time that you bond out, we give you 2 weeks from the date of your release to turn yourself in that jurisdiction. If you fail to do that, the bond that I set here now, I'm going to revoke it, set it at 0. I will not give you another one. I will issue a nationwide warrant for your arrest. You can't run forever. I will get you, and this time I will physically hold you. And it doesn't matter if you're nursing this or if you're doing that. I don't care. You need to understand that. I cannot show you favorable treatment. I understand that you're nursing, but I have to treat everybody the same way. It doesn't matter if Jesus was here. I have to treat everybody the same way, and I do. I try to be as fair as possible, help you out as much as I can within the limits of the law. So understand, I'm happy to set you up. Well, otherwise, because if I thought you were a danger or flight risk, I wouldn't set you a bond. So I am going to set you one, and it's a low bond at that, at $1,000. Normally it's, 5 to 10, but understand, I'm going to hold you to it. So if you just take off and you don't go turn yourself in, do you understand?
I was planning to drive over and not fly over, where it would be a little bit more easier for me to
That's
get there.
probably a good, well,
Yeah.
look,
Yeah, you'll get arrested at the
Shreya
airport.
will
We already
tell you
talked about
exactly
your
how
dad
to do it.
driving you.
You don't want to take another risk where they,
Yes, sir.
because understand, we're letting you out. That warrant is still a valid warrant. So you get stopped somewhere else, they'll take you into custody. So you have to be careful. The only other thing I'm going to say, don't wait till the last day
No, sir.
because, all right,
Understand.
quick, anything else? Question?
No, I'll meet you back.
Well, do you think you'd be able to get it today for the passport surrender for,
Me?
well,
Oh, I'll do it right now.
okay,
Yeah, I'll make sure I don't leave the court without it.
okay.
I
Then I'll
have
stand
two
down until that.
passports, so I'd have to
What?
double check.
What do you mean you have two passports? Where are they?
Because one is they're downstairs, so.
Okay, well, both of them will go.
Yeah, now it's both.
Because I think one is the H2B.
Well, guys, I'll let you
Okay.
talk about it.
Well,
And-
all your
Sorry.
passports, got it.
Yes, yes.
So this is it Lauderdale?
Lily.
Oh, right. Good morning, Mr. Lee. Sir, you were charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 5th, 2025, the officer was conducting surveillance as part of a traffic crimes task force of motor vehicles racing westbound on Grand Parkway, and the officer observed the defendant's vehicle traveling in lane 2 and another vehicle in lane 1. The motor vehicle slowed down to approximately 30 miles per hour before launching at the same time in a competitive manner, accelerating to well over 110 to 125 miles per hour in an attempt to outpace each other. The motor vehicles raced 3 times, then pulled into a Buc-ee's. The officer observed the defendant, but was unable to locate the other motor vehicle involved in the race.
So then it says that also he picked up a felony evading he was on bond for a felony evading and now he's picked up this case, a racing?
It looks like that's the case, Your Honor. He was on bond for the evading.
I'm taking away your privilege to drive. You are not allowed to drive, Mr. Lee. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what is going on in your life. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. This is an affidavit that you're going to promise me that you're not going to drive. Do you understand? There's a burning building with 50 kids in it. I don't care. Do not drive. You mind filing those conditions as well, please? No driving.
No driving? Yes, Judge.
Have a lawyer. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Johnson. He will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, you pick up another case, I'm going to revoke it. And if I find that you're a danger to the public, I'm going to make it sky high. I will do everything in my power to protect my public at all costs. Do you understand? You want the same day as the felony?
Sunday is totally fine.
Yeah. Okay. All right, guys. I'm going to have you sign a reset. We'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it. And then after that, you'll be free to go. All right. Thanks, guys.
The felony's all the way in June 2nd.
Mr. Lee, 2026, Your Honor.
Is it set for trial or something?
No, he was on that's a placeholder setting because it was a PTI.
What's going to happen with that? Is he still in the PTI?
It was, from my understanding, I don't know. I think it was some conditions he had to do it. He's almost done with it, so I think he's close. I don't know.
So is that, do you know whether they're going to keep him in? Do they know about this?
I'm sure they know, but
does the felony court?
I'm not attorney on that.
You're not the lawyer.
No, but they.
Okay. So let's just do this. Let's just do it right. We'll do a 30-day reset. And then I don't know what's going to happen upstairs. We'll see. You just keep us in the loop. Okay. All right. Good to see you.
Good to see you.
So you are Kenneth Allen, correct? So Mr. Allen, we had started to do probable cause, but I wanted to wait. No, over there. So that we get your perspective on it. So, all right, so you stand charged with criminal trespass. You're facing up to 6 months in jail. We're going to do probable cause again now that your lawyer's here. Okay, please.
On December 30th, 2024, the officer was dispatched to a doctor's office in Harris County, Texas, in regard to a criminal trespass. The officer made contact with the complainant and the witness, who both stated the defendant had an appointment at the doctor's office several hours prior, was asked to leave, and the defendant stated he was not going to leave. The officer found the defendant, and the complainant and witness pointed to him, stating that it was indeed the defendant. The officer told the defendant he needed to leave or he would be arrested, to which the defendant refused, stated, "Let's do this," and turned around, putting his hands behind his back.
Is the witness?
So let me see, Your Honors.
I mean, he had authority to be there, and I know that you can revoke that, when you overstay your welcome.
Yes,
right?
Judge. So the complainant is the office manager and the witness is security guard.
Okay. Did you want to add anything?
Well, Judge, my issue is he's been at that facility for years, and he has 3 separate doctors within the same UT facility. And he was there for his doctor's appointment. And there's some contention as far as whether he was asked to leave or not, considering that doctor's appointments take months to schedule in advance, sometimes up to 6 months. So I don't believe that if he had a right to be able to see the doctor, I don't believe that a person that's unidentified, the original complainant, I think her name was Amy, should be able to come in and tell him to leave, if in fact she told him to leave. So I think there's.
I know, I guess here we have an office manager that's telling him to go, refuses to, so then the security gets involved.
Yes, Judge. And then he still refused to leave once security got involved. And we contacted the complainant as well, and to add.
You had spoken to the complainant?
Yes.
Oh, okay, tell me.
And the complainant said that the defendant was sitting in the lobby after his visit, and the reason he was asked to leave is because they had a prior incident where they investigated him doing some inappropriate conduct, and that's why they asked him to leave after his visit had concluded, and then he refused to leave.
Do they still want him not to go over there? I mean, I think that there's probable cause to go forward now. Did you speak to them? Tell me.
They said he's no longer a patient.
No longer a patient. Okay. So you can't go back there. Okay, Mr. Proler, you must find a doctor, but it appears that they don't want you to go there anymore, at this particular doctor's office. Okay.
Well, Judge, not adding, like I mentioned, he has 3 separate doctors within the same building. So is the court asking him to stay away from that particular single
Correct.
office?
Right.
Okay.
So if you have business in another part of the building, you can go. Just don't go back to this office, because chances are, if you go back there, they're probably going to call the police and they're going to charge you with another trespass. So don't go back over there, because they've warned you not to go back. If you go back, you can get charged again. Go to the other offices, like, hopefully they're just not next door, because that's going to be a real pain. But okay, so then just stay away from wherever that office is, and you can use the other 2 places. But I'm not barring you from the building, just from going back to that particular office. What is the confusion?
Oh, I want to bring to your attention this alleged other incident.
Doesn't matter.
Yeah.
Okay.
It doesn't matter. The only thing, my concern is going forward. Right. You were on notice now that you're not supposed to go. What suite is this?
It's a UT Physicians Bel Air station, so I don't know how they organized that office there. So I think just one system. It's not necessarily separate offices, like different. Just be
If he has 2 other doctors that he sees there.
And that's part of the issue, because again, it's part of the same system. So I don't know. They do have multiple doctors there, but it would be at the same facility. And they told us that he's no longer a patient at the facility. So presumably that means no doctors there, but we could clarify if you would
I
like.
think you need to.
Yes,
You definitely need to, because this could be a potential problem.
yes, we can
And
certainly
he's saying
clarify.
he's still seeing two other doctors
Yes,
there. They may not know of the other two doctors. You want to do that real quick to see, real quick? Can you give me 5-10 minutes? Let me see. So, hey, Alex, also see, are there different, in most like buildings, there's suite 101, 102, 201, 202. How do they do it over there?
Yes,
Is it by
Judge.
like
We'll see how they organize.
the suite, and then
Yes, Judge.
is it possible that he can see the other two?
Yes,
And then, okay, yeah.
So, I was doing my due diligence on my end. And
Great.
I made contact with, another provider in the facility. He is a current patient there at this time.
Right.
So I just wanted to verify on our side.
Alex, did you hear this?
Oh, I apologize.
And Will, because this is your deal as well. So they've verified that council has verified that he's seeing another doctor at that facility.
Okay.
So what we'll do, like I said, you are on notice of what you can and can't do. We don't want you to go to the complaining witnesses in this over there, wherever they may be, wherever their office is. You understand? You can see your doctor if you have another doctor there, but I don't want you to have contact with these people here.
If I understand you correctly, Judge, I can continue doctor's appointments there, but don't.
How is the facility divided up?
This building is not the best building to have doctors in, to be perfectly honest with you. But you get off the elevators or stairwell, whatever route you choose, and it kind of wings off. Let's say.
Is there a possibility that you're going to run into these people?
The same floor, separate floors.
Yeah, I'm sorry, under what circumstances, Judge?
I don't want you to run into these people.
And when you say these people,
is there a way you can get to your other doctors without going to the cardiologist? In front of that building, in front of that suite?
oh, I think I understand what you're saying.
Is there a different way you can go around?
I mean, it shouldn't be this difficult.
I know. I agree.
I don't understand why what is the doctor's name, or what is the facility? Who are we talking
So
about here?
talking about an Amy Whitetree. So she's the office manager for whatever department she's in.
I don't want you to have contact with these people.
Can I tell you something, Judge? I don't know. I mean, I now know who she is, but she did not identify herself on the date of the incident.
Okay.
And she didn't have a UT badge or anything. Some woman came and talked with me. Now I understand she has a name. And sure would like to hear the complaint is the name, if that's okay with you all.
I don't want any more issues. If they call me and they say that you're becoming a disturbance there, I'm going to revoke your bond and I'm going to put you in jail. Do you understand? I don't want to make this any more difficult than it is. You know what you can, you know what you can't do. The condition of your bond is you're not to have any contact with the complaining witnesses in this case, not to go where they work. They don't want you to go where they work. That's it. If we get wind that there's any issues, only one thing's going to happen. You know what you can and can't do. I just don't know how else to explain it. But
I understand.
Sure, that's pretty clear. And that'll be the only condition, Judge. This is his first contact with law enforcement. He's a retired captain of the Houston Fire Department for 22 years.
Okay.
So he's not going to be in trouble whatsoever. It's the misunderstanding.
yeah, and if it gets to the point where you may need to find another doctor because it becomes impossible for you not to run into them, but you're the one that's on bond for this case, right? We'll give you as much as we can, but I just don't want any more problems. I don't want them to live in fear. I don't want them to live in, oh my God, is he going to come back? No, we've told you what the expectations are. That's it. Okay. If you have any questions, you've got a lawyer. He can help you out. If there are any issues that arise in the future, you can always come back here. We have an open door policy. So we're always here for you, whatever you may need. Don't take matters into your own hands. and just be good. That's it. We'll have conditions for you to sign after you're done with that. Then you're on your way.
Thinking appearances are way for.
Correct.
Okay,
So
thank you.
because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court here, but you must stay in touch with counsel and he will tell you when you have to come back to court.
Sure, sure.
If he tells me that you've gone AWOL and he can't get a hold of you, you're not answering phone calls or text messages, that's when we revoke bonds. You pick up a new case, I'm going to revoke the bond. Okay? All right, guys. All right. So they're going to have it filed, let you sign it, and then you're on your way. Okay. Of course. Thanks.
Simmons hyphen Urban.
Page 11 and 12.
You picked up a new case, Miss Simmons.
Simmons
Urban. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You now stand charged with the offense of criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine.
Yes, Judge. The officer was dispatched to a club in Harris County, Texas in response to a disturbance. The complainant, an employee of the club, told officers that she had asked the defendant to leave and the defendant refused. The defendant had been trespassed by another officer the day prior, and the complainant stated the defendant continues to return to the location. During the incident, when the complainant told the defendant to leave, the defendant stated, "Leave me alone or I'll hit you in the head." The defendant told officers that everyone at the location was trespassing and that she should have been given a pink paper in order to be trespassed.
Okay, ma'am, I'm going to find that there's probable cause to go forward with the case. You've picked up a new case. The only thing I asked you to do was not pick up a new case, and now you've done it. So what happens now? Corey?
Judge, I'm going to ask for you to allow her to remain on bond. The state hasn't filed, if that's what you're getting at. The state hasn't, the state hasn't filed a motion to revoke bond. I'm not prepared for it. If they have, ask for time for a hearing to be set. So we can, have a hearing based on evidence. She hasn't violated the bond conditions, from the previous case as far as they relate to going to the housing authority.
She has, though. One of the conditions is behave yourself, give no facts or rise to probable cause so that you violate any new laws. She's now picked up a new case.
What it is related to your very specific orders about her not to go back to the address where her apartment was or the Houston Housing Authority address. She's complied with those terms.
But if I let her go now, that's enabling this behavior and telling her it's okay.
Well, Judge, I think it would be punitive if you put her in jail as opposed. Well, that's not the purpose of bond, right? It's community safety and the community.
She's threatening people allegedly there to beat them in the head. She won't leave.
That's hearsay. Let me just talk.
Taking you into custody, man.
Judge, that's hearsay. I think we're entitled to a hearing.
Yes, I'll give you a hearing. Sure. Whatever you want.
My arm is broke.
I don't know how else to, she's going to do whatever she wants to do. How am I supposed to handle this?
I'm not a threat to the community, so I'm not understanding. And as I said, that is hearsay. Is there any way, can you subpoena the cameras? Because I didn't threaten anybody. And there is also multiple witnesses that was there as well.
Sure. So that's my job. That's not the judge's job. And I'll do that just like I've done for the previous case. So Judge, can we allow her to remain on bond until we have an actual hearing following the rules?
I haven't been around them.
Following the rules of evidence for bond revocations.
Here's what we'll do, Corey. What I'm going to do is I'm sending you for a drug and alcohol test now. If you fail to take the test, if you fail to do what you're supposed to do, I am going to revoke your bond and put you in jail. I'm now putting a GPS monitor on you and I'm giving you a curfew of 9 p.m. to 6 a.m. Do you understand?
Okay, 1 second. I'm homeless because they have refused to let me back into my apartment.
I'm not going to talk to you. This is not a negotiation.
No, I'm
It's
not.
either you follow the conditions of bond or I'm going to revoke it and put you in jail.
Okay.
This is better than being in
whatever
jail,
you want.
unless you want to be in jail.
Your lawyer's asking me not to put you in jail now.
Well, how long
because you
will I be in
picked
jail?
a case.
Until November the 22nd.
No, I'm sending you for a drug and alcohol test now. We are going to reset this case until Monday. You are to come back Monday so we can address it. In the interim,
I did consume alcohol. Not anytime soon, so that's fine.
I want you to listen. I'm going to put a GPS monitor on you and I'm giving you a curfew of 9 p.m. to 6 a.m. Do you understand?
Where is my curfew supposed to be from is the question. Because if I'm currently homeless and I am sleeping on the city streets, residing, because they refuse to let me back into my apartment, where
know what you're doing.
where is that supposed to be at?
That's what these conditions I'm giving you, ma'am.
It'll be within an exclusion zone. We do, do you feel an exclusion zone since you
Sure.
have a permanent
Oh, okay.
address in?
But I don't. I'm ordering you not to consume alcohol or illegal drugs. And I'm going to randomly test you, but I'm saying you now for a test, you're to come back Monday. Do you understand?
That's fine.
Okay. I'm giving you a monitor on your ankle. I don't want you going to any clubs, bars, or anything of this nature. Do you understand?
That's fine.
Thank you, Judge.
See you Monday.
Yes, sir.
And I'm sending her now for a test. I want to know what, if anything.
Where do I go to take this test?
She'll tell you.
Curfew's 9 p.m. to 6 a.m. Okay, so if she's homeless, we need a home base for the GPS to observe people.
That's what I was trying to say.
She's got to live in somewhere. Got to be living.
I don't have friends or family or nothing, so that's what I'm saying.
You put your head somewhere down at night.
Yeah, on the city streets.
We'll get an address for it. Thank you, Judge. It's better than jail.
Yeah, it's not gonna be Xavier's either.
Maybe excuse me.
Craig.
Good morning again.
Hey. Your last name again, sir? What was the last name? Johnson. Thank you. You were Donald Johnson. Mr. Johnson, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 17, 2025, the officer was dispatched to the theft of a motor vehicle at a residence in Harris County, Texas. The officer made contact with the complainant, who advised that his truck was stolen off the property at 12:42 p.m. and the complainant showed officers clear footage of the theft, where the officer observed 3 white males exiting a motor vehicle, one suspect going under the hood of the complainant's vehicle and getting in the passenger seat, and another suspect drive the motor vehicle off the property. The officer got the suspect's motor vehicle's license plates, ran that license plates through Lens, and got an address. When the officer arrived at that address, he observed the motor vehicle used to commit the theft in the driveway and knocked on the door and met with all parties inside the home. All subjects matched the subjects on surveillance, and the defendant had the same clothes as in the footage. The defendant admitted to, the second defendant admitted to driving the motor vehicle and showed where he dumped the vehicle, and the complainant's vehicle was recovered. The first defendant, Mr. Johnson, admitted to helping the second defendant steal the motor vehicle.
So you're telling me that they allegedly stole a car?
Yes, Judge.
He's charged with a misdemeanor theft, Class B.
Yes, Judge.
What is the value of the car?
According to the DIMS, the complainant advised the value was $600.
Does he make a statement that he knows the car's stolen?
He makes a statement that he admitted to help steal the vehicle.
Okay. All right, Mr. Johnson, I'm going to find that there's probable cause to go forward with your case. We do have co-defendants in this case, do we not?
Yes, Judge.
I'm ordering you as a condition of your bond not to have any contact with the co-defendants in this case and not to have any contact with the complaining witness in this case. You pick up a new case, you endanger my community, I'm going to revoke your bond, I'm going to put you in jail, and I'm going to make it extremely high. Do you understand, Mr. Johnson?
I do understand.
What do you do for a living, sir? How do you support yourself?
Sir?
How do you support yourself?
I'm trying to get disability right now, sir.
All right, I'll help you fill out an application. Do you mind giving me an application? Do not leave until you sign our bond conditions, otherwise
Yes,
I will
sir.
issue a warrant for your arrest. I'm going to give you an application. I'm going to have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir.
Right this way.
Mr. Francisco Silva, he's a custody judge, and I wonder if I'm wrong on his.
Is that C or an S?
It's the judge.
Okay.
Okay.
Good morning, Mr. Cerda. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes, Judge.
I don't even know where to start.
Judge, my concern is, if you may, I want to just bring some, I guess, some points of argument to the court's attention. The first one, my concern is that, I mean, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people, or the individuals that have taken this U-Haul. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the four corners of the things, allege that my client was involved with this alleged theft.
I mean, remember, like, so when they start an investigation, sometimes they just don't have everything, and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul.
Yes, Judge.
And they've given a description of a tall, lanky person, right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Cerda remained in the U-Haul. There's no further information regarding Cerda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality? Like,
and Your Honor,
can you just, does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough.
Dude, I'm with you.
Oh, yes, sir.
But so
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have the information. We'd have to await the OR, and we don't have at this time.
But I'm not going to sit here and hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because, you know. $7102.
No. Magistrate. There's no information in the DIMS for this defendant at all. And we have no OR. So just discuss the refile.
Are you looking at it?
Yes, great.
A person commits an offense if with intent to establish, maintain, or participate in any combination or in the profits of a combination or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as is pled, is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence and the information in the DIMS, but right now Chief is looking at it.
And Your Honor, if we could just maybe reset for a week or so, we call the witness. and we have to
No,
deny-
he's in custody, and I can't, I mean, if he was on bond, that would be one thing, but he's in custody. I'm not gonna hold him just because, and the compounding it, Casey, is that he's got an ice hold, so I can't give him a PR bond,
I would just need, I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Sir, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, Okay. All right, for sure.
Counsel.
Mr. Lewitt, are you Miss Troyan Marie Britton?
I am.
Miss Britton, you are charged, I'm sorry, you are wanted out of Georgia, Fulton County, Georgia specifically, for possession of a firearm or knife during a commission or of an attempt to commit. I don't know what, it just ends there.
Felonies, Judge Fleischer.
To commit certain felonies. Your lawyer has asked for me to set you a bond. I don't know. I don't know anything about you. I've never met you before. So I got to see who you are as to see whether I'm going to set you or not. One of the main things is, are you a danger to our community? Number one. Number two, if we set you a bond, are you really going to go back or are you just going to take flight? Those are the things that we're really concerned with here. Amy, tell me about Miss Britton or Katie, or is it you or anyone?
Yes, Judge, I'm here.
Okay.
I would be a little bit concerned, Judge. I am seeing 2 failure to appears already on her criminal history. I see a possession of a pistol by a person under 18.
Wait, what was that?
A possession of a pistol by a person under 18. Interesting charge. And then I see a failure to appear. I see possession of a controlled substance, marijuana charge, willful obstruction of law enforcement officers, and aggravated assault, theft by receiving stolen property, driving without a valid license, another failure to appear.
Is that
so I am a
four
little
failure
bit
to appears?
concerned.
That's 4 failure?
No, I'm seeing 2 failure to appear, Judge.
Were they fugitive cases or just open cases elsewhere? And where is all that history from?
So I can't tell, Judge, if it's a fugitive case or not. I see that it's out of Fulton County. Let's see. I see Atlanta Police Department. It looks like most of these are out of Fulton County, Judge.
How long ago are the FTAs? Is it recent or?
So one is from 2023 and the other one is from, trying to look for a date, Judge, is from 2024, from 6/28/2024, it appears.
And I'm assuming that 6/28 one is the one that's holding her right now.
It might be, technically the warrant that we have written down is possession of firearm. So it doesn't specify whether it's a failure to appear warrant or
when the
not.
hold was placed?
Let's see.
She was booked on our.
It looks like it.
7th.
I'm sorry, it looks like it's from February of 24. Yeah, it doesn't, like I said, it does not specify that it's for the failure to appear.
Judge, so she hasn't been before your court. This is one of those cases where I'm not asking for a PR bond. I'm asking for a bond that would ensure that she turns herself into Fulton County. I've talked to her about your requirements if you were to set a bond, how that affects her, how that affects the bond. She needs to present herself. She's got criminal history, I'll give you that, but she hasn't been before your court before. We're asking for an opportunity for her to go turn herself in. She's willing to do that within the 14 days and show proof of that. If she doesn't turn herself in, well, then I got nothing to say, but at this point, it sounds like possession of firearms are most of the cases that she has.
All her cases are dangerous cases.
Correct.
Assault, ag assault, possession of a pistol. Now she's got a pistol case, committing certain felonies. We don't even know what the felonies are. Do you know?
No, Judge, not at this time.
I only heard of
A bunch of FTAs, at least 2 other FTAs. Now we've got a third. What? You really want me to set you a bond? I want hair. Not going to happen. No, at some point we got to say when. But you know, you've racked up a bunch of criminal history. How old are you? How old is she?
She's, I think she just turned 19.
19 and all this?
Was I right about that, Troy?
Correct.
Absolutely not. I'm in shock that you're 19. And Katie, how many priors are we talking here? At least like 6, 7, 8?
It appears so, Judge, yes.
No, I'm sorry, but I just, you scared me, Miss Britton. Really, I don't think that I could trust you. I think if I set you a bond, it's something is going to happen, or you're just not going to go back. And I'm sorry, I can't. Right. The good news is that you've made bond on your other case here. So the time is ticking for Georgia to come get you.
She needs to waive today if she wants that to happen.
I'm sorry.
She will need to waive today.
So the process is that you can either waive or you can fight extradition, in which case they will get a governor's warrant, which will take up to 90 days. But if you waive extradition, that gives Georgia up to 14 days to come get you. And if they don't get you within that 14 days, then Harris County releases you. But at 19, with as many priors as you have, including 2 failure to appears, you really scare me. And I don't think that it would just, that it's time to pay. Just can't trust you, Ms. Britton. Sorry.
Would you consider any amount?
No, I mean, all that, and you're 19, it's hard enough being a person of color in today's society. And now with all these priors, all you're doing is you're digging yourself a grave. You're making yourself unemployable. You know, this life can be a great journey where you buy nice things, you take nice vacations, you get married, you have kids, and they come up to you, hey, I love you, mommy, I love you, daddy, you know? Or it can be a rotten, miserable of an existence where you're in and out of jail at 19. All these serious priors, come on. Stop. It's time to grow up. And me giving you a bond now would be just enabling you and telling you what you're doing is okay. It's not. And now we'll wait for Georgia to come get you. Thanks.
Thank you, Judge.
Good morning, Mr. Sarmiento.
Señor Sarmiento.
You
Bien, señor Sarmiento.
were charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
Yes, Judge.
I'm going to go slow.
Yes, Judge. On January 5th, 2025, the officer became aware of a stolen vehicle via a flock alert. The flock alert was for a listed stolen blue Hyundai. The officer checked the vehicle's license plate and observed the vehicle stolen as of December 21st, 2024. The officer observed the vehicle turning northbound onto East Tex Freeway, taking the ramp heading north on East Tex Freeway, and ran the license plate, confirming the vehicle to be stolen. A traffic stop was initiated. The officer announced themselves as HPD while giving command to turn off the vehicle and place hands out of the vehicle. The defendant, the front passenger, was the last to exit the vehicle, and the officer made contact with the complainant, and the complainant stated he did not know the defendant, did not give the defendant authorization to operate the vehicle.
What?
So they found the stolen vehicle, Your Honor.
How does he know that it was stolen?
And Your Honor, there's no need for him to know this vehicle. There's no requirement he knows, only that he's in the vehicle without permission from the owner. And the owner said he does not.
How does he even know that the person driving stole the car?
Well, he doesn't know the defendant. He doesn't know. He didn't say he know he's stolen. He just didn't know him. Did not get permission.
So you're telling me that he's in a car, he doesn't know the driver, and
right, the complainant just said that in regard, he did not know the defendant, did not give.
I understand that. I get that, but so he's he's a passenger in a car, and they charge him with criminal trespass. And in the DIMS, it says that he doesn't even know the driver. So how would he even know that the car is stolen? How do they know each other? I'm beside myself. I don't. When a criminal trespass requires some kind of like notice that, hey man, you know,
So the trespass was the driver driving into the area and he was this kind of.
he's the passenger, right? I would assume that the driver got charged with UUMV.
Let me see what he got charged with.
If you tell me no, I'm gonna lose it. Really?
Yes, Judge, UMB.
Okay. But the problem is that like, how would he know that the car is stolen? Right? You got to give me something that it's a specific intent crime. You have to, you know, there's got to, in my opinion, you've got to somehow know that the car is stolen. And
Your Honor, further, I guess to get to that, he was in a relationship with the defendant who was in the vehicle, and there were signs of damage to the vehicle that the officer articulated, saying that there was. One moment.
A scratch on the hood.
Signs of theft that would lead a reasonable person to believe the vehicle was stolen, as the steering column was broken in a manner that only a screwdriver could turn the vehicle on, and the screwdriver was tagged into the evidence. So there was damage from a screwdriver in the vehicle indicating that it was stolen, and this defendant was in a relationship with the driver of the vehicle. And then furthermore.
Did you just tell me that they didn't know each other?
No, the complainant does not know the defendant.
Oh, okay. I thought you also said that the driver and.
No, Your Honor, it may be misunderstanding because of me, but it's the complainant saying he does not know this defendant and did not give permission to the defendant to operate the vehicle.
So there is enough there that a reasonable person would believe
that
he's in a stolen car.
Yes.
So the steering column was
broken, and the officer said that in a manner only a screwdriver could turn the vehicle on.
See, I don't know, you know, because when I was young and dumb and 17, and, you know, my friend had a CJ7, you know, you ever been in those Jeeps that are just jalopy Jeeps, right?
Yes,
they
yes.
always broke down. They always had a problem. We always, you know, Jimmy rigged it as well, you know?
In this case, Judge, I believe there would be enough for PC because we have a vehicle with evidence of breaking into the vehicle with that damaged steering column.
I've been in vehicles like that before.
And we furthermore have a complainant saying he doesn't know the defendant in the vehicle.
That no difference to me.
That goes to the element of without, for the criminal trespass, it goes to the, with, knowledge that it was,
Nah, I'm not, no, I'm sorry. I'm gonna find no probable cause. I'm sorry. Be careful. When you hang with dogs, you get fleas. I don't know what your status is in this world, if you're in this country with permission. But if you go to jail and you're not in this country with permission and you spend any kind of 4+ hours in there, immigration will put a detainer on you and you will be stuck like Chuck in there until you get shipped to immigration. So live like a halo, especially if you're not well documented in this country. Go ahead, take a seat for me, sir. Mr. Montoya, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 50 days in jail with credit for the 50 days that you've done.
Yes.
Oh, he has another DWI. Did you see that?
Well, there's a question whether it's in.
So Freestone County has a hold on this gentleman for a DWI above a .15.
He doesn't acknowledge that, Judge.
He has a prior DWI from the same place. You need to realize something, Mr. Montoya, that this now may very well be your second DWI conviction because you're pleading guilty to this DWI. Once you have 2 DWIs, when you pick up a third, you're looking at a 3rd-degree felony, 2 to 10 in the penitentiary. Is that what it's going to take? Prison time? Some people only learn the hard way. Is what it's going to take. Watch the news. Every single day in our county here, someone dies from a DWI when it is extremely easy. One button on a phone, an Uber will take you wherever you need to go for $30 freaking. From now on, you may be very well facing up to 10 years in prison, even with a sip of alcohol because of your record. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. It will be there for the rest of your natural-born life. Do you understand?
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
Don't kill anyone. That's all we're asking. Don't kill anyone. We have enough death on the streets as it is. You have a DWI here. You have another one open somewhere else. You have one from last year. What's it going to take? I'm suspending your license. Is this pled as a first or is it pled as a second? I'm suspending your license for a year. Do not drive. Stop driving. I'm not asking for much, man. Really. Good luck to you, man.
Nice old Judge.
He still has another DWI in another county, man. Really. I have done everything in my power to try to keep you out of custody. You have 2 open DWIs. I was now going to grant the fact that you had negotiated an intensive outpatient treatment. You now are testing positive for alcohol and marijuana while you're on bond for this case. And I have told you repeatedly that you are at no tolerance, Mr. Jones.
I don't do drugs. Period and point blank.
I have here.
Don't say anything. Can I get a copy of the bond violations before we discuss it?
Is it impending?
It's, yeah, it's in ready for judge.
I don't know why it's not cool.
March 13th, the results were confirmed by the lab for alcohol and THC. Oh, wait. Joshua Dante Jones, right? Joshua Dante Jones? This has got, I don't know, something's wrong here.
I'm not understanding. I'm not saying.
Something's wrong. Oh. We need to put pretrial services on probation, man.
I'm not sure.
I mean, it says here, Mr. Jones,
I don't see it in ready for judge.
no, it's wrong. It's wrong. Let me see it. It's wrong. Let me see. Yeah, it's wrong.
Okay.
It's a Joshua Dante.
Okay.
It's the exact same. You're good.
So we're good.
Hey,
Okay. It wasn't you. We're good.
that's not you.
Let's go talk again.
Sorry to scare you.
Let's go talk.
He's good. I want to apologize for getting mad at you. I had the wrong person, so it wasn't you. So I'm sorry for raising my voice and getting upset with you. And the reason I got so upset was because you have 2 open DWIs. It's serious business. It's not a, and so if I see someone that has those kind of cases that are open and then they start having more violations, that really tells me that there's a problem, which is not your case. I mean, I haven't seen any violations, which I'm hoping it stays that way. The idea is that you learn something when you get here, so you leave better than you came, because the last thing we want is for you to become a statistic. We have enough of that. We don't want any more. We don't want any more death on our streets. That's exactly what we're trying to prevent. And everything we do now here is to help you and give you the tools to make you better when you go out in the world, so that you think next time, if you do want to get lit, right? If you want to have 32 shots of tequila, 52 joints, or whatever it may be, right? That you think before getting into a car. Because God forbid, it's that one mistake that you dig such a hole you never crawl out of. That's the idea, You've worked a great deal here, really, where they're going to dismiss one of your DWIs, you're pleading to the other one. Nevertheless, when an officer pulls you over, the first thing they do, what do you think they do? They look at your record because they want to know who they're dealing with. If they look at your record and they go up to you in the car and they smell alcohol or dope, it's probably not going to go well. So the idea is, if you're going to get lit, if you're going to have that, be like that, take an Uber. Do you understand? The agreement that you've worked out is, like I said, they're going to dismiss one of the DWIs. You're pleading guilty to one of the DWIs, so it will go on your record. You are now entering into an agreement, a plea bargain with the state. The agreement is 180 days in jail to be probated for 15 months. As part of the agreement, you will do a DWI education class, 2 victim impact panels. You will do a TRAS with conditions. You have already done the TRAS. The TRAS has recommended intensive outpatient treatment, followed by supportive outpatient treatment, which is good. I'm telling you, I thought they were going to order you to do inpatient treatment. That's what I thought they were going to do. So this is great for you because you're not going into lockup. But understand, it's not easy. You have to get it done. If you don't, Do you understand? No drugs, no alcohol, no breath test refusal. So if you're pulled over in a car, an officer asks you to submit a breath test, you must do it. Guardian interlock, a $100 one-time donation to Mothers Against Drunk Driving, and 25 hours of community service. I will make you a deal. Your license is now suspended. I had them look it up to see whether you can drive or not. You can't drive now because your license is suspended. It's suspended until 2026 as to what they state saw and looked up. If you get your license back, I will waive that community service for you. I would rather you spend the time to try to get your license back and get liability insurance, car insurance. If you do, I'll take off the 25 hours of community service. You understand? If you fail at this agreement, I will issue a warrant for your arrest. I'm going to bring you back out. We're going to have a talk about whether you violated this probation. If you do, you're looking at 180 days in jail. You understand?
Stop.
The worst possible thing you can do is just take off. If you do, that's an instant warrant. The other worst possible thing, if you pick up another DWI. If you do, I'm just going to lose even more hair. Don't, really. If you ever have a problem, come back, talk to us. We can always work it out. There's never nothing that we can't work out. Anything can be worked out. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty to this offense, it will go on your record. You can never take it off. Is this what you want to do? How do you plead to the offense of driving while intoxicated?
Yes.
I'm going to find you guilty. I'm going to follow the agreement. I'm not going to suspend your license. It's already suspended because of the ALR hearing. So don't just start driving until you get it back. Because you don't have a license, we're going to order you to get a portable device. I've been paying for it now while you're on bond for this case. I can't pay for it any further. Reduce his fees, please. The other thing that you need to understand is DWI is big business. There is a $3,000 surcharge that one normally tack onto this. I'm going to take it off now. But from now on, you ever pick up another DWI, that's a second. From now on, it's a minimum of 30 days in jail and a $6,000 surcharge on a second DWI. Do you understand? All right. Good luck, sir. Thanks, Jimmy. You can wait now.
All right, just listen to everything Joe's gonna tell you.
You speak English, right?
Yes, sir.
Mr. Arzola, I'm bringing you out because with us, you're on bond for a terroristic threat. The next day you pick up a criminal mischief, or maybe it's the same transaction, I don't know. All I know is that now you've picked up a felony violation, you picked up a violation of protective order with us. And the bond is set at $100,000 on it. I have no idea what happened. We're going to find out. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, do you need to hear criminal mischief and
No, just the
just VPO?
VPO, please. If you could be loud.
Yes, Judge. On April 30th, 2025 in Harris County, Texas, officers were dispatched to a disturbance call. Officers arrived and met with a complaining witness who stated that the defendant is his son. Complaining witness was informed that the defendant was causing a disturbance at his shop and wanted him to criminally trespass. Defendant refused to leave and refused to sign a trespass warning given by officer. Officer then found the defendant had an active protective order prohibiting from being at the location.
So this is the terroristic threat, I imagine, had the protective order.
I believe so, Your Honor.
And so the court knows, I think the one that ends with 9-2, that one was no PC'd. I think that one's being dismissed or was dismissed, but that leaves open the other three cases.
Oh, there was another terroristic threat.
There's two terroristic threats. One was no PC'd, and I believe that's being dismissed. And then there's just so the court knows.
I guess I didn't realize they're all basically within the same. So what happened on the terroristic threat and the mischief, I guess?
On the mischief, Judge, on April 28th, 2025 in Harris County, Texas, officers met with a complaining witness who said that the defendant is his son. Complainant would say the defendant struck several vehicles with metal pipe, breaking the taillight left panel and damaging the front hood of the vehicle. Complainant would say the defendant then started arguing
Is there any
with him
evidence?
and gestured a handgun and acted like he was discharging it. That's on the.
That's a terroristic threat.
You what?
That is
Can you read that again?
correct, Your Honor.
He acted like he had a handgun. Did I get that?
And acted like he discharged it.
So a imaginary gun is a terroristic thing? Like pew pew?
Well, it says, did then and there unlawfully threaten to commit an offense, namely murder upon a member of the defendant's family, namely Jesse James Arizola Sr., hereinafter called the complainant with intent to place the complainant in fear of imminent serious bodily injury.
I have a little more, Judge, too.
Okay.
Sorry. Defendant, used his right-handed gesture, a handgun, acting like he discharged on him while stating that he was going to kill him and all of his family members.
Why? No, something.
I mean, I just got it, Your Honor. So I had, I need to look at everything. I haven't seen anything yet.
Ms. Arzola, I'm going to find that there's probable cause to go forward with your case. I can't give you a PR bond, man. Just, you scare me. The last thing I want is I don't want you to go back, and I don't want you to do something that you will eternally regret. It's mom and dad, man, Look at me. What's going on with you?
I filed some paperwork, Your Honor. Just so you know.
What I'm going to do now, Mr. Arzola, I'm going to have you speak to some people because we need to figure out how to go forward. I don't know. Just don't go back over there. Do you understand? I don't know if you're going to get out, but if you do, I'm putting a monitor on your ankle and I don't want you to go back over there. I'll obviously give you a bond reduction on the 100,000. I think it's a little excessive, but I'm going to revoke his PR bonds. He was on a PR bond. I'm assuming he was on a PR bond and went back. Is that right? Because the first offenses happened on the 28th. Now the VPO.
And this, so the VPO has sent that, Your Honor.
And it has been assigned to DVD or.
Right, so 2 days later it goes back, and so that's why.
So it's not going to be theirs, but I don't know who the DVD prosecutor is.
Can you get all the
They're going to share everything they have with me, yes, sir. Can take a
the
little time.
police badge numbers and the police that were there
Yep.
that arrived?
It'll be in the report once I
It'll be
get
in the
the
report. Everything.
And can we go to trial?
We sure can, but it's one step at a time, okay? We're not there yet, but we can go to trial if that's what you want to.
So Arzola, my only other thing I'm going to ask you is that I don't know if you're taking anything, some kind of illegal substances,
Drug free?
but are you supposed to be taking anything?
No, I'm drug free.
No. Are you supposed to be taking
No.
anything? Have you talked to a doctor or they prescribed you anything? Because we can have you also talk to a doctor too, to see if
I'm
there's
not
something you be taking. I don't know. I'm trying to just
concerned about anything like that.
help you out so that you don't pick up more things. That's it. So look, I'll let you talk to Greg. You guys figure out how we go forward. So I'll set the bond at 5,003 on the VPO.
Okay.
I want you to understand something, Mr. Arzola. I'm issuing a protective order now on the violation case. If you violate those conditions, I can have a hearing to hold you at zero bond until these cases are over with. Do you understand? The only thing I'm asking you to do is don't have contact with your dad. Don't go over
Criminal
there.
charges?
Their
Exactly.
charges are terroristic threat of a family member, Criminal mischief and violation of a
Alright.
protective order.
And what I want to say is that the so-called claiming police trespassed on my property.
Okay.
So I'm trying to say that those charges are bogus, all those charges.
Noted.
Well, look, the evidence is going to point to whose side is correct. I don't know. We weren't there. But it'll take time to get the evidence. There'll be body cams. And when we get everything, we're going to show it to you so you can see what happened as well. Okay? Hold on.
So the one is 5,003, Your Honor. So what are the other two bonds?
So hold on. Can you file, a protective order has not even been filed on the VPO. Can you file it so that we can do it?
Yes, Your Honor. We can, we'll have Sebastian.
So what I'm doing is I'm now entering an order, Mr. Arzola, that identifies Mr. Arzola Senior as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section. Yeah, we will, but
I feel that what you're saying is really irrelevant because the impersonating police officers that trespassed on my property gave me bogus charges. So the police, the so-called police that arrested me, I want to go to trial.
We're going to go to trial, but we're not there yet. Okay.
Let me do this one last thing, though. I need you to listen real quick, Mr. Arzola. The protective order says that you cannot go within 200 feet of where your dad lives, where your dad works. You cannot be in possession of any of the weapons. You cannot communicate with this person in a threatening.
I'm mentioning that I'm not concerned.
Should be.
Well,
this just says you can't go there. We'll talk about everything else in trial.
Someone explain.
If my family, my parents didn't write any police report or sign any paperwork, I'm not concerned what is being said.
I'll have Greg reach out to your folks to figure out what they say. Okay? You cannot stalk your parents. You cannot be in possession of a firearm or use anyone else to communicate a threat or harassing behavior to your father. All right, we're going to have him sign everything, Greg.
Okay.
We'll sign your motion. And then,
Well, I want to go to trial and I want to be appointed a new lawyer, a court-appointed lawyer.
just raise it up by $1.
Okay. So that makes it what?
1,001.
1,001, not even sugar.
Okay. All right, Mr. Arzola, we're going to have you sign these documents. After that, we'll have you go.
I want a new court-appointed attorney.
You just met him. Okay. But we need him to sign stuff, okay? GPS prior to release, no drugs, no alcohol. Hey, what's he got in his fingers there? He grabbed something.
It's gone. It's gone.
You gonna sign my evaluation? Okay, thank you.
I don't know if it's like.
If it's what?
Go. I don't know.
I don't know, but I mean.
And then whatever you need, we'll give it to you, you know?
Okay.
Just wave the signature. It's okay. Wave it.
Okay, so I'll explain the.
So tell me.
A review of the body cam, we did see the failed signal. In addition, we did see the high mounted brake light out, which is a third brake light. And under the Texas Code, section 547.3215, the federal vehicle equipment safety standards are adopted. And federal regulation 49 CFR 571.108 requires a high mounted rear brake light. And because that was out, that is the.
But not all cars have that.
What?
Well, so are you telling me now every single car has to have that third mounted brake light?
It requires any multi-purpose passenger vehicle, which in this case it was a sedan. So in this case it is a passenger vehicle. So it has to have, and you can see on the body cam, Your Honor, you can see the high mounted brake light. That's not a truck, no sedan. Well,
And I would point out, sure, it requires the
I don't,
vehicle
no,
to
no, no,
have.
no, but did you really see that there's no turn signal?
There's no turn signal and
I would like to see that.
yeah, we can see that. It's,
Can you show him what you saw, please?
oh, yeah, because she can pull up the video faster than I can.
We have the video ready.
Oh, okay. Time stamped at 0.08. It's keep going. So you're gonna see the vehicle come into view at a distance right there, and he comes across 2 lanes without signaling.
Bro,
You can, come on, Will, you can.
we can show the judge that.
Yeah,
'cause
we
you
can,
can't-
we
you
can
can't
step in
see
the
that.
back and you can see
I
it
don't think
cut
that's
across.
him.
There's no way.
There's no way that's him because
But-
he's already in the furthest right lane by the time that,
No, you
in
can see
2
him, you
seconds
can see him
later.
going across to his right, a lane without any signal and addition to that brake light as you continue the video.
Would you like to see, Judge?
Sure.
Let me see.
You will see a vehicle here.
Which car?
It's a, may I, Your Honor, go up there and point it out?
The truck?
No, it's the gray sedan. The gray sedan come up.
Oh, it hasn't come up yet.
You won't see it until after the law enforcement goes over on that.
He looks like he's going pretty fast, huh?
No.
No.
No, we're just.
There is people kind of,
So when you go, I mean, the law is such that you're always supposed to signal, right? And I mean, even if you're going in that turn,
Well,
I mean, were the lights on at that point or no?
yes, the lights were on as soon as he gets up to the back of my client's vehicle before he makes that turn, they just shake lights. And the state is saying that there was an unsignaled lane change fire.
How do you know the lights are on?
Pardon?
How do you know?
There's a sound kicks on, you can hear it.
Yeah, and he's correct that after, but before that, there's an unsignaled lane change as.
Yeah, well, I was hoping to see an unsignaled lane change before they even pulled them.
There is, Your Honor, it just.
Show me that.
He said it was a freeway.
Well, freeway, Your Honor. And-
Show me. I didn't see it.
Yeah, well, if I could, I can point out his vehicle.
Yeah. Show me because that's what I was looking for and I didn't see it.
Your Honor, if I may step around, so I can.
Go, please. Come on. Don't be shy.
So it's small, it's at a distance, but you'll see the vehicle come into view momentarily. It's right there. That's the defendant's
That's
vehicle.
him?
That's the defendant's vehicle. Let me go back a little bit.
No way telling us.
Because you can continue, no, and you can continue seeing it.
Can you not make it? You should be able to like.
I'm sorry, if we're gonna do crosstalk like this, we can just set this to an MAJ hearing or formal motion to suppress, and that can be up on the big screen. We can have more structure to an argument, and we don't have to have 3 people arguing about it, or you that's a personal handheld device.
Yes, Judge. And that's the.
I guess you want to set it for a formal probable cause
Well,
hearing?
you know, he's on an MAJ out of this court, well, we just have the MAJ. It's a preponderance standard, they can challenge any motion to suppress they want to, or they can urge any motion to suppress they want.
This is for the new case though, right? This
It
is not for the MAJ.
It's for the new case.
It's for the new case.
Yeah, the UCW.
The UCW, yes.
Yeah, but he's got a pending MAJ in this court for an evading arrest.
Right, but because of this.
Right, so this would have to be proved about that hearing anyway.
Right, but I mean, I'm not going to revoke if there's no PC to go here.
Right, but I'm just saying if we're going
So-
to be here having 3 attorneys talk about a handheld device on the screen what can't be seen, we might as well just set it for a whole hearing and then we can put the whole video up on the screen.
I'm down. You want to do it for beginning of next week?
The court suggested that there's gonna be.
I didn't realize it was going to be this
Yeah, I just.
labor intensive, so to speak, you know?
It's turning into like a big argument. If the video is clear enough to determine probable cause, then that's fine. I'm just saying if this is gonna.
I'm having to squint. So that's why, but let's set it for a formal one. Next week, whatever you want. No?
I mean, wherever the court wants.
It doesn't matter to
I mean,
me.
but on the, I would like to do it now if we can, just that willing, but we're in the I mean, it's the first 8 seconds of the. The car is so far away, there's no way. The state's gonna point out a minuscule car hundreds of yards away, and can't see what lane it's in. It's the same.
There, and then the officer continues going in that direction. It's the same vehicle.
Is it that one way over there?
It's
this one, Mike.
the one going right at that time. Because it's going right, then the officer continues in that direction, follow the vehicle.
Can we see it right here? Which one is it?
So it's not right here, it's
How does he even see that?
because as he's coming around the corner, you see it right there, that vehicle right there going right.
Oh, that was cool how you did that.
Yeah, I don't know how I just you on it.
That's great. That's it.
So yeah, as he's coming around the corner, yeah. So he's coming around, and then that vehicle going all the way across with no light, and then
Look.
Can you tell what lane he's in?
No. Come here, Will. Look. Here. He hit something that made it like really big.
Hey, Alex. You can fix everything. No.
You can see him. He's like, hey, he's cutting off to try to get out. Maybe, you know. Mr. Mercer, do you want to talk about something else?
Yes, sir.
Tell me.
Rehash the previous subject. I was talking to Mr. Martin, the guy who's from San Diego. February 7th, be too late for him to come down here.
It's okay.
Okay, thank you. I appreciate it.
For sure. But, you know, tell him between now and then, he's still not to get, he still has bond conditions that he got from the magistrate. So make sure that he knows that those bond conditions apply, even though he hasn't been here. So, okay, yeah.
I think he'll be okay.
I'm okay with that. Yeah, for sure.
Okay, so is that a finding of PC?
Yeah.
Okay, we address bond conditions then, back to where we were here in the first.
Come up, Mr. Worthy. Can you see if he has a driver's license, please?
It's eligible, Your Honor.
Okay. You're not allowed to drive unless you have also car insurance. Do you understand?
So I have liability.
Okay, good. Don't pick up a third case. If you pick up another case, holy moly, I'm just going to lose it. Do you understand? Don't. No, you're not supposed to have weapons. No drugs, no alcohol. Did you say there was an odor of marijuana here?
yes, Judge, a strong odor of marijuana.
Okay, I will test you 45 days from today. If you test positive again for marijuana, I'm going to lock you up. Do you understand? No more smoking weed. So let's set this off 45 to 50 days. His appearance is required. He will get another test on that day. If he's clean, we'll just continue him and then just goes normal. If he's test positive, get ready. You hold the keys. Do you understand?
Sir.
Okay. All right, guys. Thanks. This is Alex. All right, let's finish up. Ready?
Okay. Next is page. So it's more presumptive for THC, benzodiazepines, and.
But I haven't done those, sir. Like, I haven't.
Sorry, Charlie. Goes with you. Sorry, Greg.
What was the third one, Judge? Oh, okay.
That's it.
What is the reset date, Your Honor?
He'll pop up on tomorrow's docket.
So Thursday or Friday, whatever.
So
day.
yeah, he'll pop up on Thursday's docket. I'm gonna revoke the bonds. I don't know what they're set at now.
I'm in your court Thursday, so sounds good, Judge. I'll
Yep.
be there. All right,
Okay.
thanks.
Thanks, dude.
Yeah, have a happy New Year, Judge. Thank you.
You too. Hey, have a great New Year. Sorry, bud.
That's all right. Bye.
For what it's, hey, Greg, for what it's
Yeah.
worth, I was gonna let him slide, on the, but.
On the marijuana, yeah, I get it.
No,
I
no, no, no,
understand.
no, no, no. On the fact that he's going to a bonding company at 9, whatever, but
Oh,
you're
gotcha.
testing positive for benzos, forget about it. No way. Just,
Okay.
okay. All right, bud, have a great New Year.
Okay, you too. Thanks, Judge. Bye-bye.